senior members, colleagues, and friends in profession, and my colleagues in Managing Committee for Ernakulam branch of ICAI. Welcome again to the virtual webinar on new labor codes, with a special emphasis on ESI, PF, bonus, gratuity, and shops and commercial establishments act, organized by Ernakulam branch of ICAI. As mentioned by Jaws, in the previous session, we had some technical glitch, and though the Gratuity Act was well covered, PF, ESI, and other acts were not fully covered or not clearly covered. So it was decided to redo the session, except the Gratuity Act today, once again, for all of your benefit. Today again, Mukunda sir came forward to do the same, and it's a great gesture on his part. Friends, as I mentioned to address us, we have with us Advocate CPE Mukunda sir. Every one of us knows him. He's a very sought after faculty on labor laws, specialized in labor laws, and he's practicing in Kerala High Court. And he's always here as a regular feature here in our ICAI Ernakulam branch CPE meetings once in a year. So we are sure that this session, the reading session, will be more beneficial to all of you. Let me welcome Advocate Advocate Mukunda sir to this webinar. Please welcome, sir. Let me also welcome Advocate Liti Teresa Madam also to this webinar. Friends, today we are using this Zoom meeting. As you know it very well, if you put on the audio, it will create problems. So please keep remaining mute on audio and video. Whatever queries you can have, you can raise it in the chat box or query box, and I'm quite sure Mukunda sir will address all those queries. And please see that you fully involved in these discussions. Let me welcome each and every one of you present here today, in this second day also, to this webinar. I welcome Secretary Jaws, Vice Chairman Ranjit, and all other Managing Committee members to this webinar. Hope you will have a wonderful learning time today. Thank you. Over to Jaws, please.
Thank you, Chairman Sierra Varghese. I'm very happy to introduce our speaker for this session, Advocate CPE Mukundan. He served the ESI Corporation for about 20 years in various capacities. He voluntarily retired from ESI Corporation in the year 1996, and he started practicing as an advocate. Since then, he is practicing mainly concentrating on labor laws. He is the chief consultant of Messrs. Norms Management Associates, which is the most leading professional labor laws consultancy organization. At present, he is acting as a labor law consultant for hundreds of reputed national and multinational companies on retainership basis. He has authored 4 books, mainly ESI Act and Employers, Thozhilalikalum ESI Paddhathiyum, EPF Act and Employers, Bonus Niyamam Ottanottathil, and Gratuity Niyamam Ottanottathil. These are a few books he has authored. And he writes in most of the dailies, including Malayalam Manorama and other business magazines. On every Monday, Malayalam Manorama News Daily is publishing a column on labor laws authored by him. And he also had a speech with the All India Radio and other electronic visual medias. And he, along with Advocate Little Teresa, will be taking this session. Little Teresa also is a part of his consultant firm, Norms Management Associates. With these words, I introduce our speakers for today. And I request our Mugundan sir to commence the session. Over to you, sir.
Okay. Good morning to all of you. Good morning.
Good morning, sir.
Good morning. Once again, I am extending my heartfelt thanks to the office bearers of around at ICAI for having me invited to lead this discussion. Really, I'm sorry we could not complete our session on Monday. The fact is that during the last 1 month alone, I had participated more than 20 webinars. On day-to-day basis, I am attending webinars, either as a faculty or as a panel member or as a participant. Never I had experienced such technical issues which happened on last Monday. I am really sorry. I seek your apology for the inconvenience caused to you. Okay, let us start our session. Okay.
Sir, I think as of now, all are Malayalis, Kerala, from Kerala.
Okay.
So
in both, yes, okay. Yes. Anyway, you all are aware that we are conducting this seminar in the wake of the amendments or codification of labor laws took place recently. For the last 5 or 6 years, we have been hearing a lot about the codification of labor laws or simplification of labor laws, which will suit to the ease of doing propagated or promoted by the central government. I think we shall have a look into the circumstances which led the central government to undertake such an exercise. You may be aware that in our country, to run an establishment, at least 60 labor laws, major central labor laws, and around 10 state labor laws have to be complied. See, you know, the labor comes under the concurrent list of our constitution. Then both the central government and the state government have got concurrent jurisdiction to enact laws relating to labor. That may be one of the reasons for the multiplicity of labor laws in our country. In no country in the world has got this much number of labor laws. Even in the communist country, China, or in the socialist country or capitalist country, USA, only 2 labor laws are existing. But in our country, there are more than 60. And the employers' organizations have been demanding or clamoring for the reduction of labor laws in our country. I need not explain the difficulties or the sufferings or of the establishments to ensure compliance under various labor laws applicable to them. Under each law, an entrepreneur or employer is supposed to maintain a good number of registers, to submit a good number of returns, to exhibit a good number of notices, extracts of various labor laws, and to make payment of contributions under various labor laws. Then he has to seek registrations or licenses under each labor laws. All the more, he has to face inspections by different authorities one after another. See, nowadays, during the last 5 or 6 years, the government has directed the enforcement officers not to make repeated inspections. Only if there is a complaint then only inspection can be done. But formerly, it was virtually an inspection raj. One day ESI, second day EPF, next day a factory inspector, then labor officer under different labor laws. The entrepreneur had to set apart a considerable time to ensure compliance under various labor laws, to sort out the issues raised by the bureaucrats, I mean labor officers or inspectors. Then naturally, there was strong demand from the part of employers' organizations to have a uniform codification of the labor laws. In fact, Mr. Ravindra Verma, who was the chairman of the second Labor Commission, he had submitted a report in the year 2002, which he had recommended codification of labor laws into just 5. But unfortunately, that report was lying in the shelf unattended for the last 15 years. Some 5 years back, it was searched out, the desks were cleared, and the process started. Now it has become a reality. All the 4 labor codes have been approved by the Parliament on 22nd of the November. 3 labor codes were introduced in the Lok Sabha. I'm very sorry to say that even without any discussion, all the 3 labor codes were passed by the Lok Sabha. It is really deserving. We cannot appreciate it. The very next day, that is on 23rd, all the 3 labor codes were placed before the Rajya Sabha. Then on 29th, all the 3 labor codes got the assent of our president. And it has been notified in the Union Gazette on that day itself. Then a formal notification we are expecting from the Union government, the date, declaring the date from which all these 4 labor codes will come into force. See, as a matter of principle, we have to welcome the codification of labor laws. My considered opinion is that it will help both the establishments and the employees. Not only the employers, but it will be beneficial to the Indian economy as such. It may attract more foreign investors to our country. In fact, a lot of things have been liberalized. The definitions, important definitions, have been made universal. Formerly, wages under ESI Act, EPF Act, Factories Act, or ID Act, all were differently defined. All were different. Even a labor law practitioner or a labor law advocate cannot follow the definitions given to wages, employees, worker, establishment, employer, like that. Now everything has been universalized, simplified. We have to welcome the move, the initiative by the side of the central government. Then let us examine what are all the labor codes which have been enacted in our country. See, the most important labor code, I will say, that is Industrial Relations Code 2020. Once this code is coming into force, 3 important labor laws will get repealed. What are all the 3 labor laws? One is Trade Union Act 1926. It was a creation of British people. Then next one is Industrial Employment Standing Orders Act 1946, also by British people. The third one is the most important, ID Act, Industrial Disputes Act 1947. ID Act is considered as the mother act of all labor laws. That is dealing strike, lockout, closure, layoff, retrenchment, then resolution of disputes, everything is covered by ID Act. All these three important labor laws are going to be repealed at any time. Then hereafter, we will have to follow Industrial Relations Code 2020. Then I would like to explain or to have a look into the important changes which will take place through the codification of IR code and wage code or occupational safety code or social security code. See, it will be better to have an idea regarding some definitions given in the IR code. Or else that may be beneficial to your offices also. See, we have to understand what is industry before going into the details of IR code. Industry, it is a triple test suggested by the Supreme Court of India. Especially during those days, our Justice, we are Krishnaiyer, a legal luminary from Kerala, was leading in those matters. He was the member in that 5-member constitutional bench which defined industry. They had suggested triple test. And accordingly, now this definition has been given. As per the definition given to the term, industry means any systematic activity. You may examine whether it will be applicable to your office. Any systematic activity carried on by cooperation between employer and worker. First test is systematic activity. Second test is whether it is carried on by cooperation between an employer and worker. For what? For the production, supply, or distribution of goods or services. Production, supply, or distribution of goods or services with a view to satisfy human wants or wishes, not being merely spiritual or religious in nature. This is the definition given to the term industry. See, employment strength is irrelevant. Even a barber shop will come under the purview of industry. Even your office also will come under the purview of industry. The only condition is that there must be a systematic activity. In barber shop, in the morning it will open, in the evening it will be closed. There will be 1 or 2 employees. Then it is being done in cooperation with the workers. Then it is also to satisfy the human needs. Then that is industry. Then industrial dispute, in dispute between workers and workers, anyway, or between employer and worker, or between employer and employer, relating to the terms of employment or non-employment. That is the definition given to the ID Act, and it has been repeated in the new code also. See, I am not going into the details of IR code. Anyway, you have to understand what is IR code. That is the most important code among the labor laws. Then you have to understand the term worker or the definition given to the term worker. You may please note that only a worker can raise any dispute with the labor authorities, labor officer, or labor court or industrial tribunal. See, among the disputes or cases dealt by the labor courts, majority of the cases belongs to the dispute regarding whether he is a worker or not. Then we have to understand who is a worker as per the IDA. Only a worker can approach. Only a worker will have the protection of the provisions in the IDA or in the IR code. A worker means any person other than an apprentice. Apprentice will not come under the purview of a worker. Employed in any industry. Industry we have already explained. To do any manual, unskilled, skilled, technical, operational, clerical, or supervisory work. Any person, yes, okay. Then we can understand that, we can see that a professional like a chartered accountant or doctor or a teacher or an advocate will not come under the purview of worker. All others will come. Of course, there are some exclusions. We will examine that also. Then we will move to the next code. Worker not included. Who is subject to Air Force, Army, Navy, Police, Jail Service, all those people are exempted. Then this is the crucial exemption. Employed mainly in managerial or administrative capacity. In short, managerial people will have no protection. They cannot approach a labor officer. Employer can throw them away on any day. They cannot make any complaint in a labor court or labor office. Next one is employed in a supervisory capacity, but there is a rider and draws wages exceeding rupees 18,000. At present, it is only 10,000. In the code, it has been enhanced to 18,000. Then, or a worker or a person who exercises by the nature of his duties, mainly of a managerial nature. Thus, we can see that managers are not coming under the purview of ID Act or IR code. Perhaps his salary may be 1,000 only, but he is not a worker. But in the case of supervisor is also not coming under the IR code. But there is a salary cap. His salary has to be in excess of rupees 18,000. In one case, that is a very famous case relating to the pilot, Air India. During those some 15 years back, during those days, his salary was around 1 lakh rupees. There was a question whether he was a worker under the earlier ID Act. Supreme Court told, no, he is a worker. He is not employed in a managerial capacity. He is not a supervisor. And he will be coming under the purview of ID Act. But a supervisor with, during those days, it was only 1,300. Exceeding 1,300 will not come under the purview of ID. That is, we have to understand it. When a employer, client is coming to me, my first question will be, what is his designation? If the answer is that he is a supervisor or a manager, then I will say, no issue, nothing to worry. Then we have to examine wages also. This is applicable not only in IR code, but also in wages code, occupational safety code, and social security code. This drastic changes have been made to the definition of wages. Wages means all remuneration that may be by way of salary or allowances or otherwise. Salary, allowances or otherwise. And includes basic, dearness allowance, and retaining allowance. Only 3 components are included in the definition for wages. Retaining allowance you may be knowing. That is applicable only in the case of seasonal factories. In the seasonal factories, there may be, there may not be job throughout the year. Then employees may be tempted to go for alternative employment, to arrest it, to prevent them from leaving the organization. Management used to give some allowance known as retaining allowance. All these only three components: dearness allowance and retaining allowance. Then what will be the consequences? That we shall explain. Then the wages have, the definition for wages has excluded a lot of allowances like bonus, gratuity, contribution to ESI, EPF, pension fund, etc. Then value of any house accommodation or of supply of water, light, medical nets or other amenities. Then conveyance allowance is an excluded item. Overtime allowance is an excluded item. Commission is an excluded item. Altogether, 11 allowances have been excluded from the purview of wages. But there is a rider. What is the rider? The allowances altogether shall not exceed 50% of the total remuneration. In short, basic plus DA has to be 50% of the total salary. Then what will be the net result or the consequences? The liability of the employers will be reduced considerably in the case of ESI contribution, in the case of EPF contribution. You know, for the purpose of ESI, all the allowances are taken into account, except washing allowance. For that also, there are some conditions that uniforms have to be provided by the employer, all those things are there. But now, everything has been made transparent, universal. You know, each and every code, this definition is applicable. Employer is supposed to follow the 50% formula. The other 50 will not attract any contribution, any liability like bonus, gratuity, retrenchment compensation, ESI, EPF. That is the new scenario in the labor codes. This is applicable in all the codes, even for ESI also, even for bonus also. Then a new concept has been introduced through these codes, a controversial concept, that is fixed term employment. What is meant by fixed term employment? The definition is employment of a worker on the basis of a written contract of employment. There must be a written contract. But there are some conditions. The benefits to the FT and fixed term employees also should be at par with the permanent employees, including gratuity on proportionate basis. You may be knowing that to be entitled for gratuity, the worker or the employee has to complete 5 years continuous service. But in the case of a fixed term employee, he need not complete 5 years. The employment may be for a period of 3 years or 2 years. He will be eligible to gratuity in proportion to the years he has rendered service as per the contract of employment. That is fixed term employment. The trade unions have strongly opposed such a concept. There are some substance in their contentions. You know, there will be no job security. Even in the marriage market, it may affect an employee. If naturally there will be a question, how far your employment? He cannot take a loan. Banks may not be prepared because his employment is only for a limited period. Then that is a new concept introduced in the wage code as well as in the social security code, then IR code also. Then in the IR code, an important amendment has been made to a definition strikes. See, formerly, what was the scenario? Workers or the union can launch a strike, declare a strike even without a notice. Many are under the impression that 14 days notice is required. 14 days notice is required only in the case of public utility services. What is meant by public utility service? That has been declared by the union government and the state government. Only electricity, water supply, telephones, gas supply, nothing else. Even hospitals have not been categorized under the group of public utility. Even the staff in a hospital can declare a lightning strike. Minnal Panimudaku. That was permissible. It was not at all illegal. No notice was required. But as per the new code, to strike, 14 days notice is mandatory. Then the maximum days, that is the period of strike notice, shall not exceed 60 days also. In short, a union cannot serve a notice declaring that they intend to strike next year or on a day after 60 days. The maximum is 60 days, minimum is 40 days. Okay. Without notice, nobody can strike. That is a development. The trade unions have made a hue and cry on the introduction of such a condition, such a restriction. Then another restriction is that no strike can be launched while a conciliation proceeding is pending before a conciliation officer. Who is a conciliation officer? Labor officer or district labor officer or labor commissioner. From labor officer grade 1 onwards are considered as conciliation officer. There is a provision in the IR code. Once a strike notice is received by the employer, he has to forward it to the labor officer or to the conciliation officer within 5 days. Then what will naturally happen? Within 5 days, the conciliation officer will commence the conciliation proceedings. Then the employees are prevented from starting the strike. That proceedings may complete after 2 months or 3 months. Then the notice period will also be over. Then immediately, if the conciliation proceedings were a failure, then labor officer will refer the matter to the labor court. Practically, it will be very difficult for the workers to strike once the code will come into force. Then, see, at present, if a worker is terminated or retrenched, employer is required to pay only retrenchment compensation. That is almost at par with the gratuity. That is 15 days salary for each years of service. But now one more liability has been imposed. That is the reskilling fund. Employer is liable at the time of retrenchment. Employer is like, in addition to gratuity, in addition to retrenchment compensation, he has to pay 15 days salary to the reskilling fund. That is an additional liability cast upon the employers. Then, very important change regarding the strike, regarding the layoff, retrenchment, and closure. You might have heard about the Chapter 5B of the ID Act, which is going to be repealed. As per Chapter 5B, an employer of a factory or a plantation or mines cannot retrench a worker without 3 months notice and without prior sanction from the government. It is a very difficult task. He cannot, see, if the employment strength is 100 or more, he cannot retrench a worker, he cannot lay off a worker. You know, you are aware that only in the extreme circumstances or emergency situations, employer will have to declare layoff. 50% wages has to be paid. See, like breakdown of machinery, shortage of raw materials, etc., may result in the layoff. For that also, employer has to seek prior permission from the state government. Even for the closure, the establishment or the factory may be running in heavy losses. Still, to declare a closure, naturally, while declaring an establishment, all the employees have to be paid closure compensation in addition to gratuity. For closure also, prior permission is required from the state government. For layoff, closure, and retrenchment, prior permission is required if the employment strength is 100 or more. See, while giving a notice for retrenchment, for sanction from the government, copies have to be served to the union, to the workers. There will be talks, there will be conciliation, and the government will examine whether it is genuine closure, whether it is a genuine retrenchment, whether it is a genuine layoff. Then only permission will be accorded by the government. Now, this benchmark for 100 has been increased or enhanced to 300. That has also courted or invited much controversy. In fact, I had an occasion to appear before the Labor Standing Committee on behalf of some employees' organization. In fact, I made a suggestion that it should be made 1,000. See, they laughed it away. They asked me, the chairman asked me, from where you got this 1,000? I got you make 10,000. In one side, Lok Sabha member around 10 or including our Elamaran Karim was in the committee, Rajya Sabha group, left side, right side, Lok Sabha members. Anyway, they had told me, they had assured me that they are ready to enhance the benchmark of 100. They were prepared to recommend 300, and the labor ministry has approved it. Now, as per the new code, the benchmark is 300, not 100. Then standing orders are coming under the IR code. Formerly, 100 employees. If there are 100 employees, this provision will apply. Standing orders act will apply. In Kerala, it has been made 50. But as per the new code, the benchmark is 300. Then there is a rider. There is a provision that the state government cannot reduce this benchmark of 300. Then in future, this standing orders provision will be made applicable only if there are 300 workers. Then we will come to our other code on Social Security 2020. IR code is already over. I have explained the important changes which are going to be taken place once it is coming into force. As a Social Security code, it will repeal 9 important labor laws, including today's subject ESI, EPF, Gratuity, Maternity Benefit Act, Employees Compensation Act. Formerly it was Workmen's Compensation Act. 9 important labor laws are going to be vanished. See, applicability, there are some amendments that we will discuss separately. See, in the Social Security Code, a new term is introduced, that is establishment. Formerly, factory was there, shop was there, all those things were there. Now, establishment. It has got a wider meaning also. We have to examine the definition given to the term establishment. All the provisions in the Social Security Code, ESI, EPF, everything will attract to establishment, provided the condition of employment strength is satisfied. See, establishment means you can examine whether this will apply to you. Establishment means a place where any industry, trade, business, manufacture, or occupation is carried out. Or factory, motor transport, building and other construction work, plantation, mine, port, newspaper establishment, etc., etc. In short, any type of commercial activity will come under the purview of establishment. Formerly, it was very difficult. Factory, different yardstick, establishment, different formula, all those things were there. Okay. I think your office will also come under the purview of an establishment. Next code is Occupational Safety, Health and Working Conditions Code. This will replace 13 labor laws, including Factories Act, Plantation Act, Mines Act, then Contract Labor Act, this ISM, Interstate Migrant Workers Act, etc., etc. 13. Altogether, 29 labor laws are going to be repealed. See, as per this code, the definition given to the term factory has been changed. At present, factory, an establishment with 10 employees with power will come under the purview of factory. But as per the new code, there must be 20 employees with power to come under the purview of factory. Then a non-power establishment or factory to come under the Occupational Safety Code, there must be 40 workers. Formerly it was 10 and 20. Now it is 20 and 40. That will also be beneficial to the employers. Then contract labor, in the case of contract labor, that also coming under the OSH code. Formerly, an establishment with 20 contract labor will come under the purview of Contract Labor Act. In future, as per the new code, the ceiling, the benchmark has been enhanced to 50. Then, under this code, this provisions relating to ISM workers will also come. As per the existing ISM Act, a worker from a different stage will come under the purview of that only if he is recruited through a contractor and only if he is engaged in our establishment through a contractor. Any directly employed ISM worker will not attract the provisions of ISM Act. Then what was the scenario? Every employer will say that I had employed him directly. There was no contractor. I had recruited him directly. Then there was no protection available to the ISM workers employed not only in the state of Kerala, in other states also. We have seen the miseries, the sufferings of ISM workers during the pandemic or during the lockdown period. Why? They had no protection. No employer was ready to take responsibility. They will claim that they were engaged directly by me. Now, the definition has been changed. ISM worker, even if directly recruited, will come under the purview of the Occupational Safety Code and he will get all the protection, all the benefits entitled to an ISM worker. Then there is a cap also, wage ceiling. An ISM worker with more than 18,000 rupees as wages or salary will not come under the purview of this OSH code. Anyway, that will be a relief to the ISM workers. Employer cannot say that he was engaged directly. Even if directly engaged, he will come under the ambit of the ISM code, ISM Act. Then next code, that is code on wages. In fact, that was enacted in the year 2019. But the government proposes to introduce or to give effect to all the four codes simultaneously. This code on wages will replace four important labor laws. One is Payment of Wages Act 1936, Minimum Wages Act 1948, Payment of Bonus Act 1965, and Equal Remuneration Act 1976. See, as per the new code, as per the wage code, new wage code, both the central government and the state government will have concurrent jurisdiction to declare minimum wages to a category of employees or to a category of establishment. Formerly, only the respective governments, only the appropriate governments had the authority to declare minimum wages. In future, either the union government can declare or the state government can declare minimum wages. If both the governments are declaring minimum wages to a particular category of employees, which will prevail, naturally, the wages which are higher will apply to the workers. Okay, central government will declare a floor wages. Then the state government cannot declare a wages which is less than that floor wages. That is going to be happen once this code is come into force. Then due date for payment. At present, in establishments having more than 1,000 employees, the due date for payment of salary is 10th of every month. But as per the new code, before 7th or earlier than 7th of every month, the salary has to be disbursed. Then, in the wage, that I have already explained, the definition given to the term wages. The only condition is that allowances shall not exceed 50% of the total remuneration. Then, relative to bonus also, we may discuss in separately. There's a new amendment. Formerly, once the act is covered, that once the bonus act is covered, applied to an establishment, it will be covered forever, even if the employment strength reduces less than 20. Now, that condition has been deleted. Then what will be the effect? If in a particular year, if the employment strength reduces to less than 20, then employer will not be liable to pay bonus. Employees will not be entitled to bonus. Formerly, once covered forever, that principle was available. Then, as per the new wage code, a recording provision has been incorporated. See, formerly, a labor officer alone can prosecute an employer for non-compliance of the provisions in the minimum wage act or payment of wages act or bonus act, etc. But as per the new code, even a worker can file a prosecution. Formerly, labor court, a labor officer had certain limitations to file a prosecution. Within 3 months from the date of noticing the offense, he has to file it. For that, he has to obtain prior approval from his superior. Moreover, he can claim arrears of minimum wages. He can direct arrears of minimum to pay arrears of minimum wage only for a back period of 6 months. But as per the new code, up to 3 years, it can be claimed. Then as per the new code, even a worker or a trade union can file a prosecution action against the employer. See, the definition to the term employee or worker has included contract worker also. In short, a security man at Reliance outlet, he may be engaged through an agency. That contractor might not have given him the minimum wages or overtime wages for the work. Normally, agencies will depute guards up to 2 hours. They will pay only 8 hours wages also. If a security guard file a criminal case in the magistrate court against Mr. Mukesh Ambani, what will be the consequence? You know, when a criminal case is filed, if it is a minor offense, he can settle through the appearance of an advocate. If he wants to contest it, then he will have to appear, he will have to seek bail, and he will have to appear on all the case days along with the offenders like involved in rape, pickpocket, murder, all those things. He has to stand in the box. He has to appear. Of course, there may be some exemptions, but he's not going to get any exemption throughout on all the proceeding days. Then ഭസ്മാസുരന് വരം കൊടുത്ത പോലെ എന്നൊക്കെ കേട്ടിട്ടുണ്ട്. വർക്കർക്ക് നേരിട്ട് പ്രോസിക്യൂഷൻ കേസ് ഫയൽ ചെയ്യാം. ഇതാണ് വേജ് കോഡിലൊക്കെ ഉണ്ടായിട്ടുള്ള മാറ്റങ്ങൾ. അത് വളരെ ഡേഞ്ചറസ് ആണ് എന്നാണ് എൻ്റെ വ്യൂ. ഇതാണ് മറ്റെല്ലാ കോഡുകളിലും ഉണ്ടായിട്ടുള്ള മാറ്റങ്ങൾ. റോയ് സാർ ക്ലിയർ ആയില്ലേ? റോയ് സാർ, okay then. Now we will enter into today's subject. See, today I have been asked to discuss the ESI Act. In the ESI Act, some important changes have taken place in the new code. Formerly, while examining the coverage of an establishment, a lot of parameters have to be satisfied, a lot of tests have to be satisfied. First of all, we will have to examine whether the area in which that establishment is situated has been a notified area. The union government, the central government has to declare a particular area, a particular village in a state will come under the purview of ESI Act. Then only the provisions will be made applicable to that area. But as per the new code, the provisions relating to ESI will be applicable throughout the country, including Jammu and Kashmir on the very first day. Then there will be no question of any geographical extension or geographical implementation of the ESI Act. We cannot say that this is not a notified area, nothing. That is the first change relating to applicability of the code. Then you may be aware that formerly, and at present, there is no provision for voluntary coverage. What is meant by voluntary coverage? What is meant by statutory coverage? You know, once it is applicable as per law, once the provisions are applicable as per the statute, then we will call it as statutory coverage. What was the condition formerly? For some 5 years back, it was very complicated. In the case of factories, we have to examine whether power is using, whether manufacturing process is there, whether it is without power. Now, even now, everything has been standardized. The only condition is that even now, 10 employees employed. There is no question of any power using or non-power using, nothing. Or even in shops also, even in hospitals also, the benchmark is 10. But there was no provision for a small unit having less than 10 employees to come under the purview of ESI Act so as to avail the benefits now available under the ESI Act. But as per the new code, even small establishment with less than 10 employees can come under the purview of ESI Act and avail all the benefits. That is known as voluntary coverage. There is also one more provision, that is an employer who has come under the scheme of voluntary coverage can opt it out also. Subsequently, he may feel that I have committed a blunder, mistake. I expected much benefits from ESI, but they people are harassing me and my employees. I don't want to continue. He can opt out. But you have to point, you have to note that once the strength reaches 10, then there is an option for decoverage or opting out. So long as the strength remains less than 10 only, he can opt out. In EPF also, hello? In EPF also, there is a similar provision, opting out. That is a new concept. Then another concept is that I told you that as per the new code, there must be 10 employees for attracting statutory coverage. But for certain types of industries which are engaged in manufacturing process, which are hazardous or life-threatening, then even if the number of employees is 1, such unit will compulsorily come under the purview of ESI Act. We cannot say that we are not having 10. For industries, hazardous industries, there is no benchmark for attracting ESI coverage. That is a new concept. Formerly, there was no such statutory coverage for less than 10. Now, for less than 10, if it is hazardous, compulsory coverage. For less than 10, if the employees and employer are willing, there is provision for voluntary coverage. Okay. Then another change is regarding the coverage of plantations. Formerly, there was no provision to apply the provisions relating to ESI to the employees of plantation. Now, as per the new code, the planter or the employer of a plantation can opt. There is also a voluntary coverage for the ESI coverage. But in the case of plantation, there is no provision for opting out. Once covered, covered forever. Then formerly, the provision was that 10 or more persons employed on any day. But that term, on any day, has been deleted from the definition. That will also have a sigh of relief for the establishment. Formerly, what was the scenario? Perhaps I may be running a tea shop with 2 employees on account of a festival or a political party's conference. I might have engaged 8 more people on a single day. Definitely, my small tea shop will come under the purview of ESI. I had come across with such instances during my practice. Now, that word is deleted on any day. Normally, an establishment engaging 10 or more employees, normally, alone will come under the ESI Act or the coming under the Social Security Code. Then in the ESI, in the definition given to the family, there is some change. As per the existing definition, there is no provision for benefits to the father-in-laws or mother-in-law, father-in-law or mother-in-law of a female employee. They will not be eligible any kind of medical treatment, nothing. But as per the new code, both the parents, natural parents as well as the in-laws, can avail the ESI benefits. And the definition to the term family has also been amended accordingly to include the father-in-law and mother-in-law also. Then relating to the ESI, suppose a factory or establishment is closed down. There was no mandatory provision that the employer has to inform or has to apply for the cancellation of the registration. But as per the new code, once the factory is closed or establishment is closed down, employer is liable to seek for the registration of ESI code or the cancellation of the ESI code and the EPF code. Then I have told you that now the scheme is, the provisions relating to ESI will be made applicable throughout the country. But there is a condition. The employer and employees need start payment of contribution only when the infrastructure for the benefits, for providing the benefits, have been established in that area. Formerly, there was no such condition. See, in Kerala, the act was extended to Wayanad district. There was practically no dispensary there. employees and their family members were required to travel more than 100 kilometers to avail treatment. But as per the new code, the liability to pay contribution will arise only if the infrastructure like ESI dispensaries, ESI branch offices, etc. have been established. Till that date, employer need not pay or need not make any compliance. Then there is a provision incorporated in the new code, that is, government will have the powers to reduce or altogether waive the contributions in the wake of a pandemic or national calamity. Formerly, it was not there, and on account of this pandemic, it was very difficult for the central government to reduce the contribution liability or to avoid the contribution liability of the employers. They had to issue notifications one after another. Then other changes relating to the powers of officers. Even labor officers and ESI officers have been given the powers of a civil court. At present, a labor officer or ESI inspector cannot search our premises, cannot seize our records. ESI inspector can verify our records, he can note down the contents, he cannot even insist for the photocopy. He will have to note down. But as per the new code, he can seize the documents, he can search out the documents, and he can take away the documents which he feels appropriate as part of his investigation or inspection. That is very dangerous. They may take away our ledger, cash book, attendance register. Nothing can be made in such registers. Then officers have been given the powers of a civil court. Now, if an employer fails to appear or an employee fails to appear before a labor officer can do nothing. ESI officer can do nothing. He can pass orders ex parte on the basis of the available information. He can assess the contribution on the basis of the available information. He cannot compel the attendance of an employer or an employee. But as per the new code, they have been vested with the powers of a civil. He can compel the attendance, and if the employer fails to appear before him, he can simply issue a warrant. Then police will reach the residence of the employer and will arrest him and produce before the officer, as in the case of a magistrate court or a civil court. That much powers are given. Then it is a very gratifying development that in the case of PPF also, there was no limitation for liability. That has been now fixed as 5 years. Then formerly, the appropriate government had the powers to exempt any establishment from the applicability of ESI Act. In fact, I have managed exemptions for a good number of establishments, especially to cooperative societies run by employees. So there may be some deserving cases. The employees themselves may be the employer. They may be forming a society to run a unit, and they may land in trouble also. I had come across with a good number of such instances. I could manage exemption for them. But in future, there will be no exemption to private establishments, only to government establishments. That power also has been withdrawn by the union government through the new code. Then I have already told you that contribution liability under ESI Act will be reduced. I think almost all the salient features, especially relating to the changes I have explained, then other things as per the existing law and as per the new law also, I would like to explain that the concept of joint liability. What is joint liability? We are taking over an establishment. If there is any liability towards ESI or EPF, I will be held liable. Then you may advise your clients that while taking over, while purchasing a new factory or an existing factory or an establishment, he has to verify whether any outstanding amounts are lying with ESI or EPF authorities. Then the last day for payment of EPF dues and ESI dues are 15th of every month. Any delay will attract interest at the rate of 12% per annum. Besides damages up to 25% per year. In short, if there is a delay of 4 years, damages alone will be equal to the principal amount. Interest at the rate of 12% for each year. But there is a rider. In the case of damages, the damages cannot exceed the principal amount. But in the case of interest, there is no such rider. In the new code also, the provisions are similar. But you may please take into notice that in the case of damages, if the employer disputes his liability to pay damages, generally the courts of law, especially the ESI courts and EPF tribunals, are quashing such orders. In the case of ESI, ESI courts are very liberal. Only in the case of damages. But in the EPF damages, the tribunal is not so liberal. He is insisting for at least 25% as damages. Then you may advise your clients, if anybody comes with a notice issued by the ESI authorities or EPF authorities claiming damages, you may advise them to approach the EPF tribunal or ESI court. There is another glad news. A tribunal for ESI matters has been set up in Kochi some 2 years back. Formerly, we had to meet, we had to travel up to New Delhi. The tribunal was available only in New Delhi. Our former finance minister, he is no more, Arun Jaitley, through his budget speech, introduced this tribunals in each and every state. That I had also met him with such a request. He was much convinced and he had assured me that your case is very genuine. I will look into it. During those, I thought it was only a normal courtesy words, but he kept his word. That may be an unprecedented through Finance Act. Now, I was expecting the amendment in the EPF Act, rooted through Labor Ministry. But the Finance Minister, through his Finance Act, introduced the amendment which enables the setting up of tribunals in each and every state. Then that is the ESI related matters. Anything more? I would like to clarify that normally when an inspection is done by ESI officers, they will, they will examine the balance sheet. What is the purpose? To see whether any wages are paid without paying ESI contribution. First of all, they will look into the salary aspect. I shall explain it with an example. That will be easy. Suppose, as per the balance sheet, total salary is 1 crore. Then they will see, they will verify for how much amount ESI contribution has been paid. That may be only for 60 lakh. Then the employer is liable to explain the gap. Why contribution was not paid on the 40 lakhs? Perhaps that may be the wages paid to the high paid employees who are not coming under the purview of ESI. Employees whose salary is more than 21,000 will not come under the purview of ESI. Perhaps in the balance sheet, you might have added, auditors might have added other allowances also like bonus, incentive, etc., then you should advise your clients when they are going to face an inspection to be prepared to explain the gap, the total amount booked in the as per the books of accounts under the head salaries and allowances and the contribution paid. Then ESI officers, authorities will insist contribution on any kind of wages, even coolie paid to a head load worker, even the coolie paid to the coconut plucker, the തെങ്ങേറ്റ തൊഴിലാളിക്ക് നമ്മളുടെ കോമ്പൗണ്ടിൽ ഒരു തെങ്ങുണ്ട്, അല്ലെങ്കിൽ വൈറ്റ് വാഷിംഗ്, അല്ലെങ്കിൽ to electrician who had attended some repair works in our shop or factory. Then naturally inspectors will insist for contribution on such heads of expenditure. See, there is a provision. They will look whether any additional construction is taken place. In the construction, there will be some laborers. They will demand contribution. In the repair and maintenance, they will demand contribution for the entire amount. But the fact is that we have to understand we are liable to pay contribution only on the wages element. Under the head construction, additional building, or repair and maintenance, there may be value of materials, taxes, transportation expenses for the profit of our contractors. We can eliminate it. In fact, it is a very difficult thing to segregate wage element from the total amount paid to a contractor. Contractor may not have supplied the such details. Put that work ourselves. Still, it may not be possible. Then we can insist or we can request the authorities that 25% may be treated as wage element. There is a clear direction from the headquarters office of the ESI corporation to treat 25% of the total amount as wage element in case split up details are not available. Normally, officers will insist initially contribution on for the entire amount. We can ask them to treat 25% as wages. Then other method is that we can always argue that the wages paid to the workers were at a higher side. See, there is a concept. High paid employees are not coming under the ESI Act. He may be a daily worker. If his daily wages is 1,000, we might have paid 1,000 rupees to a technician or to a mason. He will not come. He might have done only 2 days work. Then that formula has to apply. If that 1 day wages is multiplied by 26, if the product is more than 21,000, that employee will not come under the ESI coverage. Notional wages, what will be? Naturally 26,000. He will not come. We can argue. In many cases, I used to advise my clients to prepare a statement showing the wages were always at a higher side. That is, I think, 21,000 divided by 26. It may be around 810 something like that. But if the wages paid to a head load worker is shown as 850, he is exempted. If the wages paid to a building worker is shown as 850 or 900, next, see, we know that at present the coolie of a mason or a blacksmith is around 900 or 1,000 rupees. We can exclude such persons, but we have to do some homework. In such a manner, we have to face the inspection. Then already there is a provision that ESI cannot insist for dues for back period beyond 5 years. Perhaps the inspection might have taken place within 5 years. That is not the cutoff date. the order, the date of the order to be issued by the officer concerned later is a cut-off date. Normally, it will take 1 or 2 days, years. From you can examine, we can examine, we have to examine whether that is within the 5 years from the date of order. ESI people will say that no, the inspection was conducted some 2 years back. From that date, that 5 years limitation has to be looked into. Nothing doing. Only from the date of order issued by the assistant director or deputy director claiming contribution. Okay, I think I have covered almost all the matters relating to ESI. Sir.
Yes, sir.
Could you follow?
Pardon?
Earlier it was stuck.
Hear me?
Yes, yes.
Okay. Now we are dealing with Kerala Shops and Commercial Establishment Act 1960. In India, in every state, there are separate shops and commercial establishments acts. There is no central enactment for shops and commercial establishments. First of all, let me inform all of you that at present there are so many case laws that this act is not applicable to chartered accountant firms. So many case laws like Ramanathan versus State of Kerala and Bika Ramadhani versus ESIC, etc., etc. In all those cases, courts have the opinion that Office of CFMs is not a shop, so is to covered under the Shop Act. But it is better to know that this act for the benefit of your clients. And after the implementation of Social Security Code, shops and or other new labor codes, Shop Act also applicable to the CFNs. The objective of this act is to regulate the conditions of employment in shops and commercial establishments. This act is applied to all shops and commercial establishments, irrespective of whether labor is employed or not. If there is no employee in an establishment, for such an establishment also this act is applicable. Okay. Then we may look into the definition of shop. Any premises where any trade or business is carried on or where services are rendered to customers and includes offices, storerooms, godowns or warehouse. And in the case of establishment, and if they and a commercial establishment is also defined under the Shop Act, and it is like this: an establishment or administrative service in which the persons employed are mainly engaged in office work and includes hotel, restaurants, boarding or eating house, cafe, or any other refreshment house, a theater, or any other place of public amusement or entertainment. And also hospitals are covered under the definition of commercial establishment, but does not include a factory. In short, we can say that except a factory, all other establishments are treated as a shop or a commercial establishment. Then the definition of employee. A person wholly or principally employed in an establishment and includes an apprentice. While dealing with labor codes, we look into the definition of employee, and except apprentices appointed under the Apprentices Act, all are treated as employees. But here in Shop Act, an apprentice also included in the definition of employee. And this act is not applied to certain categories of employees. That is the person employed in a position of management. That is the managerial persons are excluded from the definition of employee and exempted from the purview of this act. And again, whose employees whose work mainly involves traveling, and canvassers and caretakers whose names not in the muster roll are excluded from the purview of this definition of employee. Then registration of a shop or a commercial establishment. Every shop or commercial establishment shall be registered within 60 days from the date of commencement of business. Now it is registered through the online website of Labour Commissionerate of Kerala, and it is very simple to register Labour Commissionerate website. Another enactment is in 2018 for the concept of ease of doing business, that is the Kerala Investment Promotion and Facilitation Act. As per the provisions of this act, if an application for registration of a shop is made, it shall be made on the same day of the receipt of application. It is clearly mentioned in the act that the registration shall be made on the same day of the receipt of application. But the validity of such a registration form B1 and the Labour Commissionerate web portal creates a new amendment and a new provision of the auto renewal of the registration of establishments. It is very simple to renew the registration certificates through this Labour Commissionerate website. And there is an appeal provision. If the application for registration or renewal is denied, and the aggrieved party or the aggrieved employer may make an appeal to the Deputy Labour Commissioner within 60 days of the order of such a renewal, such a denial. Okay, within 60 days of such a renewal. And the penalty for non-renewal. If an employer failed to apply before 30th November for the renewal of an establishment, he shall be punishable with a fine of 25% of the renewal fee. Okay, 25% of the renewal fee as a penalty for non-renewal application before 30th of November. And here is the provision for amendment of registration certificate. If there is an amendment in the registration certificate regarding the establishment name, employer's name, or the ownership of the establishment, or regarding the number of employees, such an amendment provision is to be made within 1 month from the date of such a change occurred. There is a particular form for such an amendment in form B3. It is to be made, and it is to be made online through the Labour Commissionerate website. Then there is the classification of shops. The importance of this classification is that based on this classification, the duties and responsibilities of employees are fixed. If there are more than 20 or more employees in an establishment, such an establishment is considered as a big establishment. If there are 5 to 19 employees, it is treated as a medium establishment. If there are no employees and up to 4 employees, such an establishment is considered as small establishment. Okay. Then the duties of an employer. First of all, the registration certificate of an establishment to be displayed at a prominent place of an establishment. Then give notice within 1 month of any change in particulars given at the time of registration, we already discussed. And at last, give notice within 10 days to the inspector upon closing of his establishment. Within 10 days, the closing of his establishment, the details of the information regarding the closing of an establishment must be submitted to the inspector. Then the responsibilities of a medium and big establishment. Medium means 6 or more employees in an establishment. First of all, the issuement of appointment letters. Every establishment in which 6 or more employees have worked issue an appointment letter, and there is a particular form for appointment letter, that is in form BC, and retain the copy of such an appointment letter in the personal file of the employees in the employer's office. Okay. Then the identity card. There is a separate form for identity card, that is in form BD. This provision is applicable to the big establishments. Big establishments means if there are 20 or more employees in an establishment. The responsibility of employees of all establishments, which are they? First of all, service certificate. Service certificate means the experience certificate. If an employee applies to a service certificate during the course of his service for applying for another job, or on his termination of job or his retirement or on resignation, the employer shall issue his service certificate within 7 days from the receipt of such obligation. And the copy of such service certificate must be retained in the personal file of such an employee within 7 days. Otherwise, it is punishable. There is a particular form for service certificate, that is in form BE. The another responsibility or the liability of an employer is that prohibition of retaining education and experience certificate. The Act and the rules does not allow an employer to retain the original of any employee's education or experience certificate. The other responsibilities, it is very, very, very wide, but we have to look into it. Separate latrines and urinals for male and female staff, first of all, in the ratio of 1 latrine for every 20 employees. And there is the other provision, that is restrooms with sufficient space and facilities and mandatory protective measures to be adopted, that is first aid box in proportionate to the number of employees in an establishment. And in the case of restrooms, there are so many provisions relating to these restrooms. First of all, it must be provided by every medium and big establishment. Medium means 6 or more employees. And sufficient space proportionate to the number of employees in every restroom. And the restroom must be located within or adjacent to the establishment, and separate restrooms if the number of female employees exceeds 5, and adequately furnished. The chairs, benches, the bike must be provided by the employer, and drinking water, ventilation, fresh air, and separate latrines for male and female staff in the restrooms also. Another important condition is that no electronic equipments like CCTV, etc., in or adjacent to the restrooms, so that the privacy of the employees must not be curtailed as per the law. Okay. Then the crush facilities. If there are 20 or more female employees in an establishment, in a shop or commercial establishment, the employer shall provide in free of cost crush facilities to the children below the age of 6. And in addition to that, trained ayahs for every 30 children. And the training certificate must be obtained from the State Government Training Institute for Children Caring. And in addition to that, the refreshment, toys, furniture, etc. for the children must be provided by the employer in free of cost. And in the crashes, there must be ventilation, lighting, drinking water facilities, etc., etc. Then the hostel facilities. If there are more than 50 employees in an establishment, and the employer shall provide in free of cost separate hostel facilities for men and women employees whose residence is more than 25 kilometers away from the establishment. Here, the number of employees is, if exceeds 50 employees, separate hostel facilities shall be provided. In addition to that, the hostels to have separate latrines for every 10 employees, drinking water, ventilation, fresh air, lighting, etc. Then beds measuring 6 by 3 feet, safe storage facilities, washing facilities, etc. must be provided in the hostels. Then a new provision, that is the seating facilities. That is in every shop and establishment shall provide suitable arrangements for sitting for all employees. They take advantage of any opportunity to sit which may occur in the course of their work. This benefit is for all employees. Likewise, in the media news, it is not restricted to female employees. Seating facilities for all employees must be provided by the employer. Then there is the provision for maintenance of registers and records. An employer shall maintain a register of employment and a service register and a register of holidays and leaves An inspection book, that is a book of 20 pages and recorded like an inspection book under the Kerala Shops and Commercial Establishment Act. And as per the new amendment in 2018, these registers and records may be maintained electronically in the form and manner prescribed. The registers and records under the Shops and Commercial Establishments Act may be maintained electronically. But at the time of inspection, hard copy of these registers must be submitted and authorized by the employer itself. Okay, then we are moving to the next topic, that is the hours of work. Not more than 8 hours on a day and not more than 48 hours in a week. A number of hours, including overtime, shall not exceed 10 on a day, except on a stock taking and preparation of accounts day. And total number of hours of overtime shall not exceed 50 in a quarter, that is in a 3 months period. Okay, then period of work shall not exceed 4 hours without interval for rest, at least for 1 hour. And the 1 hour rest is important after the completion of 4 hours. Okay, then spread over shall not exceed 10.5 hours. Here the spread over means the working hours and the interval for rest and the overtime. Altogether, it shall not exceed 10.5 hours in a day. Okay, when extra overtime work is done, extra wages for such an overtime work, and it is at the rate of twice the ordinary rate of wages. And opening and closing of hours, there is a provision in the Act that no establishment shall open earlier than and close later than such hours as may be prescribed by the appropriate government, that is the Kerala government. Previously, there is a provision in the Shop Act that closing of shops, and it is deleted from the new amendment of 2018. Now the shops can open and close, no restriction. That 24/7 hours of work is permitted to the shops and commercial establishments in the state of Kerala. But weekly holidays are permitted to the employees. Then here, every person to be allowed a holiday in each week. But there is a restriction, no holiday for an employee whose total period of employment in a week is less than 6 days. But this is 6 days, including any days spent on authorized leave. Weekly holidays are allowed to the employees. Then leave with wages. That is an important section. After 12 months continuous service, 12 days in the subsequent period of 12 months. That is the leave with wages. If an employee completed 12 months of continuous service in an establishment, 12 days leave is eligible to him in the subsequent period of 12 months. And this leave can be accumulated up to a maximum period of 24 days. In addition to this, during the period of 12 months, an employee is also eligible for sickness leave for 12 days and casual leave for 12 days. And especially for sterilization, that is for male staff, it is 6 days, and female staff, it is 14 days. In addition to that, there is another act, that is the Industrial Establishment National and Festival Holidays Act. If the number of employees in an establishment exceeds 20, in addition to all those leaves mentioned in the Shop Act, an employee shall be eligible for 4 days national holidays and 9 days festival holidays under the Industrial Establishments National and Festival Holidays Act. And the rate of wage during the leave period is equal to the average wages paid to an employee. Then there is the provision regarding the prohibition of employment. That is the prohibition of employment on child and women. No child, here child means a person less than 14 years of age, shall be allowed to work in an establishment. And no woman or any person below the age of 17 years allowed to work before 6 a.m. or after 9 p.m. But as per the provisions of new amendments in 2018, a woman may employ between 9 p.m. and 6 a.m. That is regarding the night. If there is some conditions apply, and the conditions must be fulfilled, the written consent of the woman employee is required, and the employer must fulfill the conditions to protect the safety and security of the woman employee, and may provide the transportation facilities from the establishment to the doorstep of her residence. Then only night shift may be allowed to a woman employee. Then the employer must display certain notices in his the premises of the establishment, and it is mandatory to exhibit these notices. Then there are certain returns, that are quarterly returns, that is in Form H, before 10th of April, July, October, and January. These returns are compulsory for all establishments if 10 or more employees are employed in an establishment. Then there is the annual welfare return, that is in Form I, on or before 15th February of every year. An employer must submit the annual welfare return. Then the provision regarding the notice of dismissal. An employee shall not dispense with the services employed on continuously for a period of not less than 6 months, except for reasonable cause. If there are a reasonable cause regarding and the fault on the part of the employee, he may be terminated from his service or on a charge of misconduct, supported by satisfactory evidence recorded at an inquiry held for the purpose. Otherwise, without giving at least 1 month notice or wages in lieu of such notice, an employee cannot be terminated from service if his service period exceeds 6 months in a shop or a commercial establishment. And at last, the penalty provisions. It is very high penal provisions as compared to other enactments. First of all, if any employer commits any breach regarding the registration, renewal, or exhibition of a registration certificate, the fine amount is ₹5,000. If the offence is continuing, ₹250 for every day of such continuing offence. If an employer willfully obstructing an inspector in exercising his powers for making any inspection, examination, etc., and the employer shall be punishable with fine, which may extend to ₹1 lakh and ₹50,000 as penalty. There are certain offences which are penal for an amount of ₹50,000. First of all, is extra wages for overtime. We already discussed that for overtime, extra wages must be provided, and the prohibition of employment of children and prohibition of employment of women during night hours without their consent and without fulfilling the conditions. Then the produce of registers or records on the time of inspection, and maintenance of registers. We are discussing about certain registers. If an employer failed to comply all these provisions, he shall be punishable with the ₹50,000 for each and every such offence. Okay. Then the penalty is ₹1 lakh for first offence and ₹2 lakh for second offence. What are they? We may look into. Then daily and weekly hours. We are already discussing about the provisions. Then interval for rest, spread over, opening and closing of shops. Then weekly holidays, leave with wages, special leave. Okay. Then wages during leave period, notice of dismissal. Then precautions against fire, cleanliness, ventilation, and lighting in the shop or commercial establishment, offices or rooms. Then appointment letter, then retaining of education certificate, then service certificate, hostel facilities, and seating facilities. If an employer violates any of these provisions, for first offense, the penalty is rupees 1 lakh, and for the second and subsequent offense, it is rupees 2 lakh. Okay, for each and every offense. Okay. Then the exemption part, government has the power to exempt any establishment or any of the or from any of the provisions of this act to an establishment that is provided under section 5 of this act. This is the end of my session. If you have any doubt. Hello?
Madam, I think there are one or two questions also.
Yeah.
This one is that what about educational institutions? Is it an establishment?
Education institutions are not covered under the purview of shops and commercial establishments. But if there is a hostel attached to these educational institutions, in the opinion of labor officers, it may be treated as shop and registration may be taken. Education institutions are not covered under Shop Act.
And asking
hospitals are covered, okay. But hospitals are covered under shops and commercial establishments.
Any minimum number of employees for registration? Is it?
No, there is no employee in an establishment. Such a shop or commercial establishment must be registered under the Shop Act.
Another question is, articled clerks of CA firms will include under the definition of employee? Question.
No. May I already discussed that there is certain case laws, that is in 1999 there is a case in the Kerala High Court that it is Ramanathan versus State of Kerala, and in 2013 there is a case in the Karnataka High Court that that is BK Ramadhani versus ESI. In all these cases, courts clearly declared that CA firms are not shops and not coming under the purview of Shop Act. At present, we also have the same opinion that CA firms are not shops. They are only professional firms.
Ronnie Jacob is asking, is profession tax liability coming under Shops and Commercial Establishments Act? Else, when liability to pay profession tax arise?
Yeah, of course. Professional tax is dealing with another act, that is Panchayat Raj Act. Under that act, if an employee employs more than 60 days in a half year, that is in 6 months, if an employee employs 60 days in an establishment, professional tax has to be paid in respect of that employee.
Is there any questions? Anyone? We are having few questions of PF is there, I think. Madam, are you going to touch upon PF, little bit PF also on that day?
Okay.
Then I think we'll have one question is there, PF. I think that later on we'll take it up. I think we can just touch upon overall what is PF, all those changes, overall thing. I think it's good.
Any more questions?
Brief briefly
Okay, I've already discussed about PF Act.
PF ഞാൻ ഒന്ന് ഹൈലൈറ്റ് ചെയ്ത് പറഞ്ഞാൽ നന്നായിരിക്കും, കാരണം അന്ന് റിസപ്ഷൻ ബാസ് അത്ര ഒരു പ്രോപ്പർ അല്ലാത്തതുകൊണ്ട് ഒന്ന് ജസ്റ്റ് ഒന്ന് ഹൈലൈറ്റ് ചെയ്ത് പറഞ്ഞാൽ.
Okay. Now we are going to discuss about the Employees Provident Fund Act 1952 and the Chapter 3 of Social Security Code that is dealing with EPF provisions. This EPF is applicable to every establishment in which 20 or more employees are employed. And there is the provision for voluntary coverage if the employer and the majority of employees of that establishment have agreed that the provisions of EPF should be made applicable. The Central Provident Fund Commissioner may give such a consent to the voluntary coverage. Then in the existing law, there is no such a provision, but in the Social Security Code, it is provided that that a withdrawal of voluntary coverage. If an establishment is taking the coverage under the voluntary coverage scheme, he may make an application to the Central Provident Fund Commissioner, and there is an agreement between the employer and majority of the employees to this effect. And this chapter may not inapplicable to such establishment. But in existing statutory and voluntary coverage are once covered forever. Now under the Social Security Code, statutory coverage is forever. An establishment to which EPF applies at the first instance, that is, if the number of employees exceeds 20 or more, shall continue to be applied thereafter, even if the number of employees therein at any subsequent time falls below the threshold of 20. Okay. Here also the definition of employee as already discussed by the Mugundan Bakki. But the difference is that in the existing law, the excluded in the definition of excluded employee, it is included that the other than an apprentice engaged under the Apprentices Act and an apprentice engaged under the standing orders of the Act. But it is not included in the Social Security Code. Only an apprentice engaged under the Apprentices Act is excluded from the definition of employee. No other trainees, whatever name may we call them trainees, apprentices, or likewise, they are not excluded from the purview of EPF. Okay. Then the counting of employees for coverage of an establishment. The employees whose wages are more than the wage ceiling, that is at present it is 15,000. They shall also be taken into account for the coverage of an establishment. Then here the provision regarding the establishment, and it is already discussed by the Mugamekil, it is common to ESI and EPF. But in the case of EPF, where an establishment consists of different departments or has branches which is situated whether in the same place or in different places, all such departments or branches shall be treated as part of the same establishment and covered under the EPF Act. Okay, wages also discussed by Mugamekil, and it is common to EPF Act. Okay, but the existing provisions of wages, it is pay, that is basic pay, basic plus DA plus retaining allowance. Here, basic wages is defined like all emoluments earned while on duty or on leave or on holidays, paid or payable in cash, but does not include which are the DA, then HRA. DA included in the concept of pay, and they are excluded from the concept of basic wages. Then HRA, overtime allowance, bonus, commission, and similar allowances. But in the case of RPFC versus Vivekananda Vidya Mandir, the Supreme Court declares that an employer must contribute on all allowances, and they are forming part of pay. This is the existing provision, and the present provision in the Social Security Code, Mugamekil clearly explained. Then we may go into the registration process and the cancellation of registration. These all provisions are common to ESI and EPF. There are so many case laws regarding the non-intimation of disclosure proceedings to the EPF, and the employers are liable to contribute that for that legally closed periods. Okay, Bharatvarsha National Association's case and the Belapur Industries Limited cases. Anyway, it is very clear from the Social Security Code that after the legal closure of an establishment, the employer must be making an application for cancellation of such registration. Okay, there is a particular form for such cancellation, and in addition to this, there are certain schemes under the EPF that are similar in the case of existing EPF Act and in the Social Security Code. That is, first of all, Employees Provident Fund Scheme, then the Employees Pension Scheme. This Employees Pension Scheme is for providing superannuation pension, then retiring pension, permanent total disablement pension to the employees of any establishment, then widow or widower pension, then children pension, orphan pension, then nominee pension. Now, another scheme is that the Employees Deposit Linked Insurance Scheme. It is for the purpose of providing life insurance benefits to the employees of any establishment. And in the Social Security Code, there is a new scheme that is for the self-employed workers. Okay. And the contribution to the funds, it is almost similar to the existing law of 1952. That is 12% shall be contributed to the Provident Fund, and from that 8.33% to be contributed by the employer to the pension fund. And it is clearly mentioned in the Act that the employee's contribution is equal to the employer's contribution. Okay. And if the employee desires to contribute more than the employer's contribution, the employee is permitted to shall be contribute. If the employee desires to contribute more than the employer's contribution, it is permissible under the existing law and under the Social Security Code. Okay. And again, the employer shall not be under an obligation to pay any contribution and over and above his contribution payable under this section. It is clearly mentioned in the Supreme Court case, that is MG Bank, Karamchari Sangadan versus MG Bank. Here, the Supreme Court held that the liability of an employer is limited to the extent of statutory ceiling. That is at present 15,000. If any employee so decides to contribute more than the statutory ceiling, he shall do so. But the employer's liability is limited to the extent of statutory ceiling. Then the contribution to the deposit linked insurance fund, at present it is 0.5%. But in the Social Security Code, it is mentioned that the amount of contribution is not being more than 1% of the wages. But at present, it is 0.5%. There is a difference in the both the code and the EPF. And there is the provision for administration charges. At present, it is 0.5%. Okay. In another concept is the contribution in respect of employees and contractors. The amount of contribution and administration charge paid or payable by an employer in respect of an employee employed by or through a contractor may be recovered by such employer from the contractor, either by deduction from any amount payable to the contractor under any contract or as a debt payable by the contractor. Here, the employer has a responsibility to ensure statement of payment for each and every month, and the conditions for recovery of such contribution amount is also to be mentioned in the contract agreement, etc. Then the priority of payment of contribution over other debts. If an employer is declared as a pauper under the provisions of Insolvency and Bankruptcy Code, the dues or any amount due under the EPF shall be charged on the assets of the establishment to which it relates and shall be paid in priority as per the existing law and as per the Social Security Code. And this EPF is not applied to certain establishments, and establishments under the Cooperative Society Act which employing less than 50 persons and working without the aid of power, and to any establishment belonging to or under the control of the central government or a state government, and whose employees are entitled to the benefit of contributory provident fund or old age pension likewise to any other establishment set up under any central or state or another law for the time being, and whose employees are entitled to the benefits of contributory provident fund or old age pension. Okay. And the provisions is related to transfer of accounts. If an employee employed in an establishment to this EPF applies, relinquishes his employment therefrom and obtains employed in any another establishment to this to which establishment this EPF is applies or not, his PF account and pension account may be transferred to the subsequent establishment. Then the appeal to a then the provisions is regarding to the appeal to the tribunal. The appeal may be on the determination and assessment of dues and levy of damages. Every appeal shall be filed. There is a separate form and manner and time. And filing that appeal in the tribunal, an employer has to be deposited 25% of the amount due from him as determined by an officer. It is clearly mentioned in the Social Security Code, but in the present existing EPF Act, an employer shall deposit 50% of the amount due from him. It is very beneficial to the employees that the deposited amount is reduced to 25%. Then the provisions is regarding the inspection scheme. As per the provisions of Social Security Code, there is the inspector cum facilitators are appointed, and they frame an inspection scheme, and it is based on the web-based inspection scheme. And for the purpose of inspection, they assign a unique number to each establishment. For conducting this inspection, the inspector cum facilitators have a wide powers that to examine any employers and to ask for them to produce any document, search, seize, or take copies of such registers, etc., etc. Then the employees must maintain certain registers, records, and returns. As per the provisions of Social Security Code, an employer can maintain such registers and records in electronic form. That is, registers must be maintained in electronic form, and the wage slips must be issued to the employees in electronic forms, and file such returns in electronic form. And there is the provision that employer not to reduce wages. No employer in relation to an establishment to which this EPF or this Social Security Code is applicable shall, by reason only of his liability for the payment of any contribution under this code or the existing act, the wages of any employee not to be reduced as per the law. Okay. Then the provisions are regarding the assessment and determination of dues from the employer. First of all, the assessment is regarding the applicability of this EPF Act or the third chapter in the Social Security Code, or the determination of the amount due from any employer. For that purpose, the authorized officer conducting an inquiry, and the inquiry must be, and for that, no proceeding under this section shall be initiated after the expiry of the period of 5 years from the date on which the dispute is referred is occurred. It also clearly explained by Advocate C.B. Mugundan in detail. This provision is common to EPF and ESI. Okay. Then interest and damages, all the provisions are common to EPF and ESI. Then there is a provision of recovery of any amount due. For the purpose of recovery of any amount due from an employer, the recovery officer, on the basis of a certificate issued by the authorized officer, shall proceed to recover the amount specified there in from the establishment. And the clearly explains about the modes of such a recovery. that are namely attachment and sale of the movable or immovable property of the establishment, or arrest of the employer and his detention in prison, and appointing a receiver for the management of the movable or immovable properties of the defaulter. First of all, the amount is recovered from the properties of the establishment. If it is not sufficient, then the recovery officer may move such proceeding against the property of the employer for recovery of the whole or any part of such arrears. Then we are going to the last part of this session, that is the offences and penalties. As per the provisions of Social Security Code, it is very high penal provisions. If an employer fails to pay any contribution, that is in case of failure to pay the employee's contribution, which has been deducted by him from the employee's wages, he shall be punishable with imprisonment for that is not less than 1 year and liable to fine of 1 lakh rupees. And in the case if the employer deducts or attempts to deduct from the wages of an employee the whole or any part of employee's contribution, he shall be punishable with rupees 50,000. In contravention of the provisions of this code, reduces the wages or any privilege or benefits admissible to an employee, he shall be punishable with rupees 50,000. Or if an employer fails or refuses to submit any written report, statement, or any other information required under this code, he shall be punishable with rupees 50,000. If an employer obstructs any inspector cum facilitator to complying with his duties, the employer shall be punishable with 6 months imprisonment and 50,000 rupees. Then there is the provision for enhanced punishment. In certain cases, after previous conviction, the employer convict the same offence shall for second or every subsequent such offence be punishable with imprisonment for a term which may extend to 2 years and with a fine of 2 lakh rupees. Here, there is another provision that if the second and subsequent offence is for failure by the employer to pay any contribution, that is EPF or ESI contribution or charges, cess or maternity benefit or gratuity or employees compensation, which under the Social Security Code, he is liable to pay for such second or subsequent offence. The punishment is extended for 3 years and which shall not be less than 2 years and shall also be liable to fine of 3 lakh rupees. Okay, this is some nutshells from EPF. Hello?
Jose, will you take up the questions? Jose?
Yes, 1 minute. I will 1 minute. Yeah, madam, there are a few questions.
Yeah.
Can I read it?
Okay.
See, it is understood that those who are getting a pension of less than, say, 2,000 rupees per month are eligible to get higher pension in view of the Honorable Kerala High Court decision. Only they will have to pay the difference given to them as PF plus interest. Certain people say that higher pension is eligible to those who are party to the suit filed with the High Court. It is also mentioned that since the PF department has gone on appeal to the Supreme Court, they will consider the same only after the case is disposed of by the Supreme Court. Due to COVID problems, even if we approach the PF department, the same will not be processed since there are only very few staff available at their office. Is there any time limit for claiming the higher pension by the existing pensioners? This is the question. It's a
Sir, I think Advocate CB Mukuthan is the right person to explain such a question. Okay.
Yeah, this question is, I think I'm reading all the questions. It may be PF, ESI, everything will be there. So accordingly, You can answer, sir. Both of you.
നമുക്കൊന്ന് സ്പീഡപ്പ് ചെയ്യാം. ഓക്കെ.
Yes, sir.
ഈ പെൻഷനെ കുറിച്ച് പറയുമ്പോഴേ 95 ഈ പെൻഷൻ സ്കീം EPF ഇൻട്രൊഡ്യൂസ് ചെയ്തത്. അന്ന് ഈ ഒരു വെയ്റ്റ് സീലിംഗ് ഉണ്ടായിരുന്നു. ഇപ്പോൾ 15,000 രൂപ, അന്ന് 5,000 രൂപയായിരുന്നു. 5,000 രൂപയേക്കാൾ കൂടുതലുള്ള സംഖ്യയിന്മേൽ PF കോൺട്രിബ്യൂട്ട് ചെയ്യാൻ പ്രൊവിഷൻ ഉണ്ടായിരുന്നില്ല. ക്ലിയർ ആയോ? Am I audible? ഹലോ. പിന്നീട് അത് 96 ഞാൻ പെട്ടെന്ന് അതിൽ ഹിസ്റ്ററി പറഞ്ഞാലേ മനസ്സിലാവുള്ളൂ. 96 ഒരു സ്കീമിൽ 11(3) എന്ന് പറയുന്നൊരു ക്ലോസ് ആഡ് ചെയ്തു. അതിൽ പറയുന്നു ഇങ്ങനെ ഫുൾ എമൗണ്ടിന്മേൽ ആദ്യം മുതൽക്ക് അത് ഫുൾ എമൗണ്ട് വെച്ചാൽ 5,000 രൂപയേക്കാൾ കൂടുതൽ ശമ്പളമുള്ളവര് ഫുൾ സാലറിന്മേൽ പെൻഷൻ ഫണ്ടിലേക്ക് കോൺട്രിബ്യൂട്ട് ചെയ്യുകയാണെങ്കിൽ, എംപ്ലോയറാണ് കോൺട്രിബ്യൂട്ട് ചെയ്യേണ്ടത് കേട്ടോ, തൊഴിലാളിക്ക് ഓപ്ഷൻ ഇല്ല, അവർക്ക് ആ പ്രൊപ്പോർഷനേറ്റ് ആയിട്ട് പെൻഷൻ കൊടുക്കുമെന്ന് പറഞ്ഞു. അതിനവരൊരു കട്ട് ഓഫ് ഡേറ്റ് ഒക്കെ വെച്ചു. കുറച്ച് കഴിഞ്ഞപ്പോൾ അതൊരു പിൻവലിച്ചു. അപ്പോൾ അതിനെതിരെ ഹൈക്കോടതിയിൽ പോയി. ഹൈക്കോടതി പറഞ്ഞു അങ്ങനെയൊന്നും കട്ട് ഓഫ് ഡേറ്റ് ഒന്നും വെക്കാൻ പറ്റില്ല, നിങ്ങൾക്കത് ഓപ്ഷൻ എപ്പോൾ വേണമെങ്കിൽ കൊടുക്കാം എന്ന ജഡ്ജ്മെന്റാണ് ഹൈക്കോടതി വന്ന് സുപ്രീം കോടതി പോയി. സുപ്രീം കോടതി കേരള ഹൈക്കോടതിയുടെ വിധി അപ്ഹോൾഡ് ചെയ്യാനുണ്ടായത്. അപ്പോൾ ആർക്കും ഓപ്ഷൻ എപ്പോൾ വേണമെങ്കിലും കൊടുക്കാം എന്നൊരവസ്ഥ വന്നു. അവരുടെ കട്ട് ഓഫ് ഡേറ്റിനൊന്നും പ്രസക്തിയില്ല എന്ന് നിലവന്നു. അതിനിടയിലാണ് ഒരു പുതിയ ഡെവലപ്മെന്റ് ഉണ്ടായത്. 2014 പെൻഷൻ സ്കീമിൽ സമൂലമായ മാറ്റങ്ങൾ വരുത്തി. ഈ 14 സമൂലമായ മാറ്റം എന്ന് പറയുന്നത് 6,500 എന്ന സീലിംഗ് 15,000 രൂപയായിട്ട് ഉയർത്തി. ഒരു അമെൻമെന്റ് പെൻഷൻ സ്കീമിൽ ഉണ്ടായത്. PF സ്കീം തന്നെ പെൻഷനിലേക്കും ബാധകമാക്കി. പിന്നെ PF ഡിപ്പാർട്ട്മെന്റ് അല്ലെങ്കിൽ ലേബർ മിനിസ്ട്രിക്ക് തോന്നി ഈ 11(3) എന്ന് പറയുന്ന ഈ ക്ലോസ് ഉണ്ടല്ലോ, ഹയർ ഓപ്ഷൻ, ഹയർ എമൗണ്ടിന്മേൽ, അത് വലിയ അപകടം, അത് പിൻവലിച്ചു. ഓക്കെ. അപ്പൊ പിന്നെ ആർക്കും ഹയർ ഓപ്ഷൻ കൊടുക്കാൻ പറ്റാത്ത രീതിയിലായി. എന്ന് മാത്രമല്ല, കുറെ പേര് പഴയ ഓപ്ഷൻ 11(3) സ്ട്രെങ്ത്തിൽ ഫുൾ എമൗണ്ടിന്മേൽ അടച്ചു വന്നിരുന്നു. അവർക്കും ഒരു കണ്ടീഷൻ വെച്ചു, ഇനി നിങ്ങൾക്കത് തുടരണമെങ്കിൽ, അതായത് പരമാവധി ആളുകളെ സ്കീമിൽ നിന്ന് ഒഴിവാക്കുക, അതായത് PF ഡിപ്പാർട്ട്മെന്റ് ചെയ്തത്, എസ്പെഷ്യലി ഹൈ പെയ്ഡ് എംപ്ലോയീസിനെ, ഇനി നിങ്ങൾക്ക് തുടരണമെങ്കിൽ ഫ്രഷ് ഓപ്ഷൻ കൊടുക്കണമെന്ന് പറഞ്ഞു. അതിന് 6 മാസം സമയം കൊടുത്തു. അപ്പൊ ഹൈക്കോടതിയിൽ അതിനെതിരായിട്ടൊക്കെ ചലഞ്ച് വന്നു. പിന്നത്തെ ഒരു കണ്ടീഷൻ എന്ന് പറയുന്നത്, അതുവരേക്കും അവസാനത്തെ 12 മാസത്തെ വേജസിന്റെ അടിസ്ഥാനത്തിലാണ് പെൻഷൻ തീരുമാനിച്ചിരുന്നത്. പക്ഷേ ഈ അമെൻമെന്റ് പ്രകാരം 2014 ഉണ്ടായ ഭേദഗതി പ്രകാരം അവസാനത്തെ 60 മാസത്തെ ആവറേജ് എടുക്കും. സ്വാഭാവികമായും പെൻഷൻ കുറയും. ഓരോ കൊല്ലം ശമ്പളം വർദ്ധിക്കുമല്ലോ. അവസാനത്തെ വർഷം എടുക്കുമ്പോൾ എംപ്ലോയി വിൽ ഗെറ്റ് എ ഹയർ പെൻഷൻ. പിന്നെ ഏറ്റവും മോശമായ ഒരു കാര്യം മിനിസ്റ്റർ ചെയ്തത്, 15,000-നേക്കാൾ കൂടുതൽ ശമ്പളമുള്ള ആരെങ്കിലും EPF മെമ്പർ ആവുമ്പോൾ, അത് ഓപ്ഷനിലാണല്ലോ, 15,000-നേക്കാൾ കൂടുതലുള്ളവർക്ക് മാൻഡേറ്ററി അല്ല, സീലിംഗ് ഉണ്ടല്ലോ, അവർക്ക് മെമ്പർ ആവാം. പക്ഷെ പെൻഷൻ സ്കീമിലേക്ക് മെമ്പർ ആവാൻ പറ്റില്ല. മുഴുവൻ അവരുടെ പേഴ്സണൽ അക്കൗണ്ട് നമ്പർ 1 എന്ന് പറയും, PF അക്കൗണ്ടിലേക്ക് അടയ്ക്കാം, പെൻഷൻ ഫണ്ടിലേക്ക് അടയ്ക്കാൻ പറ്റില്ല. ആ ഡോർസ് ആർ ക്ലോസ്ഡ് ഫോർ ന്യൂ എൻട്രാൻസ് ഹാവിംഗ് മോർ ദൻ 15,000 സാലറി. ഇത് ഹൈക്കോടതിയെ ചൊടിപ്പിച്ചു എന്നതാണ് വാസ്തവത്തിൽ. അപ്പൊ ഹൈക്കോടതി പറഞ്ഞു ഇതൊക്കെ തെറ്റാണ്. ഹൈക്കോടതി ആ 2014 അമെൻമെന്റ് മൊത്തം കോഷ് ചെയ്തു. അത് സുപ്രീം കോടതി ശരിവെച്ചു. അതിലൊരു അപകടമുണ്ടായി. ഈ 15,000 ആക്കി ഉയർത്തിയ പ്രപ്പോസൽ ഉണ്ടല്ലോ, അതുപോലും കാഷ് ചെയ്ത് പോയി. അപ്പൊ ജീവനക്കാർക്ക് ഗുണകരമായ അതും പോയി. ആ ഹൈക്കോടതി ഓവർ ദ സച്ച് ഡെവലപ്മെന്റ്സ്. കാരണം അവരുടെ വിധിയെ ഓവർകം ചെയ്യാൻ വേണ്ടിയാണ് ഇവർ ഈ 2014 അമെൻമെന്റ് കൊണ്ടുവന്നത്. പഴയ കേസ് ഒരു ശശികുമാർ വേഴ്സസ് EPF എന്നുള്ള കേസിലായിരുന്നു. അപ്പോൾ അത് മൊത്തം പോയി. ഇപ്പൊ ഒന്നുമില്ലാത്ത അവസ്ഥയായി. അതാണ് നിൽക്കുന്നത്. എന്നിട്ട് അതിനെതിരെ സുപ്രീം കോടതി പോയി. അവിടെ സുപ്രീം കോടതി എപ്പോഴും 2 ബെഞ്ച് ആണുള്ളത് കേൾക്കുക. അവരത് ഹൈക്കോടതി വിധി ശരിവെച്ചു. ഇപ്പോൾ EPF ഓർഗനൈസേഷൻ ഒരു റിവ്യൂ പെറ്റീഷൻ ഫയൽ ചെയ്തിരിക്കുകയാണ്. ഈ ആഴ്ചയിൽ ഉണ്ടാകുമെന്നാണ് പറഞ്ഞത്. കഴിഞ്ഞ ആഴ്ചയിൽ, ഈ ആഴ്ചയിൽ തന്നെ. പക്ഷെ അത് വന്നിട്ടില്ല, ലിസ്റ്റ് ചെയ്തിട്ടില്ല. അപ്പോൾ അവിടെ ഉണ്ടായ പ്രശ്നം എന്താണെന്ന് പറഞ്ഞാൽ, കേരള ഹൈക്കോടതിയിൽ ഉണ്ടായ വിഷയം എന്ന് പറഞ്ഞാൽ കുറച്ച് കാര്യങ്ങൾ മനസ്സിലാവുള്ളൂ. പല എംപ്ലോയീസും ഉയർന്ന ശമ്പളമുള്ളവർ ആ ഉയർന്ന ശമ്പളത്തിന് ആനുപാതികമായി PF കോൺട്രിബ്യൂഷൻ അടച്ചു. എംപ്ലോയറും മിൽമ, അങ്കമാലിയിലെ ടെൽക്ക്, ദെൻ സിവിൽ സപ്ലൈസ് കോർപ്പറേഷൻ, അങ്ങനെ കുറച്ച് സ്ഥാപനങ്ങൾ ഫുൾ എമൗണ്ടിന്മേൽ ജീവനക്കാരുടെ പേരിൽ PF അടയ്ക്കാൻ തയ്യാറായി. പക്ഷേ PF ഡിപ്പാർട്ട്മെന്റ് പൊതുവെ ഒരു ഇൻഡിഫറൻറ്റ് ആറ്റിറ്റ്യൂഡായിരുന്നു. പെൻഷനിലേക്ക് ഫുൾ എമൗണ്ട് അടയ്ക്കാൻ അവരെന്തെങ്കിലും കാരണം പറഞ്ഞ് അത് ഒഴിവാക്കും. അങ്ങനെ പെർമിറ്റ് ചെയ്തില്ല. അപ്പോഴാണ് ജീവനക്കാർ പോയത്. അവർ പറഞ്ഞു ഇവരുടെ ഈ ഓപ്ഷനും കട്ട് ഓഫ് ഒന്നും ഞങ്ങൾ അറിഞ്ഞിട്ടില്ല, ഞങ്ങൾ തൊഴിലാളി പറയുന്നത് ഇതാണ്, ഫുൾ എമൗണ്ട് ഇപ്പോൾ ഞങ്ങൾ കോൺട്രിബ്യൂട്ട് ചെയ്തിട്ടുണ്ട്, എൻ്റെ എംപ്ലോയറും കോൺട്രിബ്യൂട്ട് ചെയ്തിട്ടുണ്ട്. ഓൺലി ബിക്കോസ് ഓഫ് ദ ഇൻഡിഫറൻസ് ഓഫ് ദ EPF ഓർഗനൈസേഷൻ എംപ്ലോയർ കുഡിൻറ്റ് കോൺട്രിബ്യൂട്ട് ടു ദ പെൻഷൻ ഫണ്ട് ഓൺ ദ ബേസിസ് ഓഫ് ദ ഫുൾ സാലറി. അപ്പോൾ ഈ ഫുൾ സാലറിയുടെ എമൗണ്ട് മുഴുവൻ അക്കൗണ്ട് നമ്പർ 1 അടയ്ക്കുക, അല്ലെങ്കിൽ PF അടയ്ക്കണം എംപ്ലോയർ. 25,000 രൂപ ശമ്പളം, 25,000 രൂപയുടെ 12% അക്കൗണ്ട് നമ്പർ 1 അടയ്ക്കും. എന്നിട്ട് 6,500 രൂപയുടെ 8.33 മാത്രം പെൻഷനിലേക്ക് അടയ്ക്കും. ആ 25,000 സമ്മതിക്കുന്നില്ല. എംപ്ലോയർ അടയ്ക്കുന്നുണ്ട്, പക്ഷെ തൊഴിലാളിക്ക് കിട്ടും. അപ്പോഴാണ് ഹൈക്കോടതി ചോദിക്കുന്നത്, നിങ്ങൾക്ക് ഈ ഫണ്ട് ഇപ്പൊ അക്കൗണ്ട് നമ്പർ 1ഉം അക്കൗണ്ട് നമ്പർ 10ഉം ആണ്. 10 റെപ്രസെന്റ്സ് പെൻഷൻ, 1 റെപ്രസെന്റ്സ് PF. ഈ PF എംപ്ലോയർ അടച്ചിട്ടുണ്ടല്ലോ, ഇത് അങ്ങോട്ട് മാറ്റിയിട്ട് കഴിഞ്ഞാൽ കൊടുത്തുകൂടെ? ഒരു ബുക്ക് അഡ്ജസ്റ്റ്മെന്റ് മാത്രമല്ലേ എന്നാണ് ഹൈക്കോടതി ചോദിച്ചത്. വളരെ ന്യായമാണ്. PF വക്കീലിനൊന്നും പറയാൻ കഴിഞ്ഞില്ല. അങ്ങനെയാണ് ആ വിധി വന്നത്. അടച്ചവർക്കെല്ലാം തന്നെ ആ പൈസ അങ്ങോട്ട് മാറ്റിയിട്ട് ഹയർ പെൻഷൻ കൊടുക്കാൻ പറഞ്ഞു. അതിന് തയ്യാറായി. അപ്പോഴാണ് അടുത്ത സെറ്റ് ഓഫ് പെൻഷൻ വരുന്നത്. കുറെ പേര് റിട്ടയർ ചെയ്തു ഇതിനിടയിൽ. അവർ പറഞ്ഞു ഞങ്ങൾക്കും ഇതേ അവസ്ഥയാണ്, ഞങ്ങളുടെ സഹപ്രവർത്തകർക്ക് ഹയർ പെൻഷൻ കിട്ടുന്നു, ഞങ്ങൾ മുമ്പ് പോയി എന്നുള്ളത് ശരിയാണ്. അപ്പോൾ PF പറഞ്ഞു നോ അദ്ദേഹം ഓൾറെഡി സെറ്റിൽ ചെയ്ത അക്കൗണ്ട്, പൈസ ഒക്കെ തിരിച്ചു വാങ്ങി. അപ്പോൾ തൊഴിലാളികളുടെ വക്കീൽ ഹൈക്കോടതിയിൽ പറഞ്ഞു ആ വാങ്ങിയ കാശ് ഞങ്ങൾ തിരിച്ചടയ്ക്കാം, വിത്ത് പലിശ ഞങ്ങൾ അടയ്ക്കാം. അപ്പോഴും ഹൈക്കോടതി ചോദിച്ചു ശരിയല്ലേ, ഈ പൈസ തിരിച്ചടച്ചു കഴിഞ്ഞാൽ പഴയ പൊസിഷനിലേക്ക് സ്ക്വയർ 1 എന്താ പറയില്ലേ, തിരിച്ചെത്തല്ലേ, നിങ്ങൾക്ക് എന്നിട്ട് ഹയർ പെൻഷൻ കൊടുത്തുകൂടെ? അപ്പോൾ EPF ഓർഗനൈസേഷൻ അതിന് കൃത്യമായി ഒരു മറുപടി ഉണ്ടാവാൻ സാധ്യതയില്ല. അപ്പോൾ അങ്ങനെയാണ് ഹൈക്കോടതി ഓർഡർ ഇട്ടു, റിട്ടയർ ചെയ്ത ആൾക്കാർക്കും അവർ വാങ്ങിയ പൈസ ആ പലിശ സമയത്ത് ഹൈക്കോടതി ചോദിച്ചു നിങ്ങൾക്ക് എന്താ നഷ്ടം? അവർ വാങ്ങിയ പൈസ നിങ്ങൾക്ക് ബാങ്കിൽ നിന്ന് കിട്ടുന്നേക്കാൾ കൂടുതൽ പലിശയ്ക്ക് നിങ്ങൾ അവരിൽ നിന്ന് തിരിച്ചു വാങ്ങിക്കോളൂ, എന്നിട്ട് നിങ്ങൾ അന്ന് കിട്ടിയതായി കണക്കാക്കിക്കോളൂ, നിങ്ങളുടെ പൈസ ഉണ്ടായിരുന്നല്ലോ, അന്ന് പെൻഷൻ ഫണ്ടിലേക്കാണ് അടച്ചിരുന്നത് എന്ന് കണക്കാക്കി നിങ്ങൾ ഹയർ പെൻഷൻ കൊടുക്കാൻ പറഞ്ഞു. അങ്ങനെ വന്നപ്പോൾ റിട്ടയർ ചെയ്ത ആളുകൾ മുഴുവൻ കൊണ്ടുപോയി പൈസ അടച്ചു. എൻ്റെ അനുഭവത്തിൽ പല ആളുകളും അടച്ച സംഖ്യയേക്കാൾ കൂടുതൽ അരിയറായിട്ട് തിരിച്ചു കിട്ടി. എന്ന് മാത്രമല്ല അവർ മരിക്കുന്നത് വരയ്ക്കും ഈ ഫുൾ എമൗണ്ട് ഹയർ പെൻഷൻ കിട്ടുകയും ചെയ്യും. ഇപ്പം തിരിച്ചടച്ചല്ലോ, അതിനേക്കാൾ കൂടുതൽ പൈസ അരിയേഴ്സ് കിട്ടി. 4-5 കൊല്ലമൊക്കെ ആയിട്ടുള്ള റിട്ടയർ ചെയ്ത ആൾക്കാരുണ്ട്. PF ഡിപ്പാർട്ട്മെന്റ് ആകെ നാച്ചുറലി അവരാകെ പരിഭ്രാന്തിയിലാണ്. ഇത് എവിടെയൊന്നും നിൽക്കുന്നില്ല. അങ്ങനെയാണ് പൊസിഷൻ. അപ്പൊ അതിൽ നമ്മൾ മനസ്സിലാക്കേണ്ട കാര്യം, എംപ്ലോയർ ഫുൾ സാലറിന്മേൽ PF കോൺട്രിബ്യൂട്ട് ചെയ്തിട്ടുണ്ടെങ്കിൽ മാത്രമാണ് ഹൈക്കോടതി വിധി ബാധകമാവുള്ളൂ. ഈ പെൻഷൻ ഫണ്ടിലേക്ക് തൊഴിലാളിക്ക് ഡയറക്റ്റ് കോൺട്രിബ്യൂട്ട് ചെയ്യാനില്ല. തൊഴിലാളികളെ അടയ്ക്കുന്ന, തൊഴിലാളി സ്വന്തം ശമ്പളത്തിൽ നിന്നും തൊഴിലാളി അടയ്ക്കുന്ന, അല്ലെങ്കിൽ തൊഴിലാളിയുടെ പേരിൽ മുതലാളി പിടിച്ചടയ്ക്കുന്നത് 12% തൊഴിലാളിയുടെ അക്കൗണ്ടിലാണ്, വർക്കറുടെ എംപ്ലോയിയുടെ അക്കൗണ്ടിലാണ്. എംപ്ലോയറുടെ വിഹിതമാണ് അങ്ങോട്ടും ഇങ്ങോട്ടും അഡ്ജസ്റ്റ് ചെയ്ത് പോകുന്നത്. അവിടെ സംഭവിച്ചത് എംപ്ലോയറുടെ മൊത്തം എമൗണ്ടും PF അടച്ചുപോയി എന്ന് മാത്രമാണ് എംപ്ലോയർ അടയ്ക്കുന്നത്, ഫുൾ എമൗണ്ടിന്റെ. അപ്പൊ അവിടെ ബുക്ക് അഡ്ജസ്റ്റ്മെന്റ് ആണ്, അതാണ് പെർമിറ്റ് ചെയ്തിട്ടുള്ളൂ. അല്ലാതെ എംപ്ലോയർ ലിമിറ്റ് ചെയ്ത് അടച്ച ആൾക്കാരുണ്ടാവും. 6,500 15,000 അടച്ചിട്ടുണ്ടായിരിക്കും PF. അത് ഒരിക്കലും ഫുൾ എമൗണ്ട് നോർമലി ഒരു എംപ്ലോയറും തയ്യാറാവില്ല. മിൽമയൊക്കെ തയ്യാറായതുപോലെ അങ്ങനെ FICT ഉണ്ട്, ഫുൾ എമൗണ്ട് അടച്ചതാണ്. അങ്ങനെ വരുമ്പോൾ അവർക്ക് ഈ ആനുകൂല്യം ഉണ്ടാവില്ല. ഫുൾ എമൗണ്ട് അടച്ചവർക്ക് മാത്രമാണ് ഉള്ളത്. അതാണ് പ്രിവ്യൂ നിൽക്കുന്നത്. അപ്പൊ ഇതിനിടയിൽ ഒരു 4 മാസം മുമ്പ് ഒരു വിധി ഉണ്ടായി. അത് കുറച്ച് കോംപ്ലിക്കേറ്റഡ് ആണ്. അതൊരു ജേക്കബ് ജോൺ വേഴ്സസ് യൂണിയൻ ഓഫ് ഇന്ത്യ എന്ന് പറഞ്ഞ ഒരു കേസിലാണ്. അതിൽ വിജയരാഘവന്റെ ഒരു വിധിയാണ് ഉണ്ടായത്. അത് വളരെ റീസെന്റ് വിധിയാണ്, ഒരു 2 മാസം മുമ്പാണ് വിധി വന്നത്. ആ വിധിയിൽ ആ കേസിലെ എംപ്ലോയർ 6,500 രൂപ അടച്ചിട്ടുള്ളൂ. 2014 ശേഷം 15,000 രൂപയും. തൊഴിലാളികൾ പോയി പറഞ്ഞ എന്താ അറിയോ, ഞങ്ങളുടെ മുതലാളി അടച്ചുപോയി, സ്ഥാപനമില്ല, ഞങ്ങൾ അടയ്ക്കാൻ തയ്യാറാന്ന് പറഞ്ഞു. ഇപ്പോ അവർക്ക് റിട്ടയർ ചെയ്ത ആൾക്കാരാണ് കേട്ടോ. അത് ഫോർച്ചുനേറ്റ്ലി ഓർ അൺഫോർച്ചുനേറ്റ്ലി ആ പെറ്റീഷനും ഈ ജസ്റ്റിസ് വിജയരാഘവൻ അലവ് ചെയ്തു. ഈ ജീവനക്കാരനോട്, ആ പെറ്റീഷനേഴ്സിനോട് 6,500 എംപ്ലോയർ അടച്ചിട്ടുള്ളത് നോക്കണം. തൊഴിലാളി 6,500 അടച്ചിട്ടുള്ളത്. അവരുടെ ഫുൾ സാലറി എത്രയാണെന്ന് അറിഞ്ഞ് ആ ഫുൾ സാലറിയുടെ എത്ര രൂപ അടക്കേണ്ടി വരുമെന്ന് കണക്കൂട്ടി അടച്ചോളം പറഞ്ഞിരിക്കുക. അതൊരു പുതിയ ഡെവലപ്മെന്റാ. ഇതുവരേക്കും ഇത് ഒരു ലേറ്റസ്റ്റ് ഡെവലപ്മെന്റ് ആണത്. തൊഴിലാളി നടത്തുക, അതും പെൻഷൻ ഫണ്ടിലേക്ക് അടയ്ക്കാനുള്ള ഓപ്ഷൻ എംപ്ലോയർക്ക് മാത്രമേ ഉള്ളൂ കേട്ടോ. അപ്പോൾ കോടതി പരിഗണിക്കുന്നത് ആരടച്ചാൽ എന്താ, കാശ് കിട്ടിയാൽ പോരെ. നിങ്ങൾ എംപ്ലോയർ അടച്ചാൽ കൊടുക്കുമായിരുന്നില്ലേ, നിങ്ങൾക്ക് കാശ് കിട്ടിയാൽ പോരെ, നിങ്ങൾക്ക് വിത്ത് ഇൻട്രസ്റ്റ്. നിങ്ങൾക്ക് ബാങ്കിൽ അന്ന് ഇവർ അടച്ചിരുന്നെങ്കിൽ കിട്ടുമായിരുന്ന പലിശയേക്കാൾ കൂടുതൽ അവർ അടയ്ക്കാൻ തയ്യാറാണ്. അപ്പൊ ഈ PF ഡിപ്പാർട്ട്മെന്റിന് ഉണ്ടാകുന്ന തലവേദന എന്ന് പറയുന്നത്, ഈ തൊഴിലാളികളൊക്കെ അവരുടെ സാലറി എത്രയെന്ന് അറിയില്ല, ഫുൾ സാലറി ഉണ്ടായിരുന്നെന്ന് അറിയില്ല, അതിന് റെക്കോർഡ് ഉണ്ടാവില്ല. അതൊക്കെ കണക്ക് നോക്കി അത് വർക്കൗട്ട് ചെയ്ത് കൊടുക്കണം, എന്നിട്ട് അക്കോർഡിംഗിൽ പെൻഷൻ കൊടുക്കണം. മൊത്തത്തിൽ അത് ആകെ കൊള്ളമല്ല, സമുദ്രമായി ഇരിക്കുകയാണ്. അതാണ് സ്ഥിതി, ഇതാണ് നിൽക്കുന്നത്. അപ്പൊ ഈ ലേറ്റസ്റ്റ് ജസ്റ്റിസ് വിജയരാഘവന്റെ വിധി വെച്ച് നോക്കുമ്പോൾ ചോദ്യകർത്താവ് ചോദിച്ചതുപോലെ തൊഴിലാളി സാലറി, ഈ സാലറി ഉണ്ടായിരിക്കണം കേട്ടോ, 6500 മുകളിലും 15000 മുകളിലും. 2014 ഒരു 6500 ആ ഫുൾ സാലറി അടയ്ക്കാൻ തയ്യാറായാൽ ഹി മേ ഗെറ്റ് ഇറ്റ്. പക്ഷെ ആ വിധിയൊന്നും അന്തിമമായിട്ടില്ല. അത് ഡിവിഷൻ ബെഞ്ചിൽ കേരള ഹൈക്കോടതിയിൽ തന്നെ ഫയൽ ചെയ്തിരിക്കുക. അത് കുറച്ച് ഫാർ റീച്ചിങ് കോൺസിക്വൻസ് ഉണ്ടാകുന്ന കേസാണ്. ഇപ്പൊ ഓർഗനൈസേഷൻ ഒന്നും മുന്നോട്ട് കൊണ്ടുപോകാൻ പറ്റില്ല. എല്ലാ തൊഴിലാളികളും പറയും എനിക്കത് 12000 രൂപ ഉണ്ടായിരുന്നു, ഞാൻ അടയ്ക്കാം, അതടച്ച് ഒരു ഹയർ പെൻഷൻ വാങ്ങും. ഓക്കെ, അപ്പോൾ ഇതാണ് സ്ഥിതി. ഇപ്പൊ നമ്മൾ വി വിൽ അവൈറ്റ് ഫോർ ദ ഫൈനൽ ഔട്ട്കം ഓൺ ദ റിവ്യൂ പെറ്റീഷൻ ഫയൽഡ് ബൈ ദ EPFO റിഗാർഡിംഗ് ഹൈ പെയ്ഡ് എംപ്ലോയീസ് ആൻഡ് ഹയർ എമൗണ്ട് അടച്ചിട്ടുള്ളത്. ലോവർ പെയ്ഡ് എംപ്ലോയീസ് ആണ് സീലിംഗ് മാത്രം അടച്ച കേസുണ്ട്. അതാണ് ആന്റണി ജോണിന്റെ കേസിലുണ്ടായ ഡെവലപ്മെന്റ്, ജേക്കബ് ജോണിന്റെ കേസിലുണ്ടായത്. അത് നമുക്ക് ഇവിടുത്തെ ഡിവിഷൻ ബെഞ്ചിലാണ്. അപ്പൊ ഇതൊക്കെ കൂടി സമുദ്രമായിട്ടുണ്ട്. അപ്പോൾ ഇപ്പൊ PF ഡിപ്പാർട്ട്മെന്റ് ആലോചിക്കുന്നത് ഈ പെൻഷൻ സ്കീമെ വൈൻഡപ്പ് ചെയ്യാനാണ്. എന്നിട്ട് NPS ഇല്ലേ, അതിലേക്ക് ലിങ്ക് ചെയ്യാം. അപ്പൊ അടച്ച കാശിന്റെ NPS ഒക്കെ അങ്ങനെയാണല്ലോ, അടച്ച ഇത് കോർപ്പസ് ഫണ്ട്, ഇത് ജനറൽ ഫണ്ടിൽ നിന്നാണ് പെൻഷൻ കൊടുക്കുന്നത്. അത് മാറി ഓരോ തൊഴിലാളി അടച്ച കാശിന്മേ അത് അക്കോർഡിംഗിൽ കൊടുക്കാം എന്നാണ് അത് ചിന്തിക്കുന്നത്. അത് ട്രേഡ് യൂണിയൻ ആൾക്കാരൊന്നും സമ്മതിച്ചിട്ടില്ല. ഈ നിലവിലുണ്ടായിരുന്ന കേസ് അറിയില്ല. മൊത്തം ഒരു ഒപ്പീനിയൻ പറയാൻ പറ്റാത്ത സ്ഥിതിയാണ്. ഓക്കെ, നമുക്ക് വൈൻഡപ്പ് ചെയ്യാം. ഇതൊക്കെയാണ് അവസ്ഥ. റിവ്യൂ പെറ്റീഷന്റെ തീരുമാനം വരണം. ഇവിടെ ഡിവിഷൻ ബെഞ്ചും ഈ തൊഴിലാളിയുടെ പെറ്റീഷൻ, അത് ഫുൾ സാലറി ഇല്ലാത്തവര്, ലോ പെയ്ഡ് എംപ്ലോയീസ്. ഓക്കെ,
4 ക്വസ്റ്റ്യൻ കൂടി ഉണ്ട്, ഒന്ന് ക്വിക്ക് ആയിട്ടൊന്ന് പറഞ്ഞാൽ. അതിലൊന്ന്
കുറച്ച് അധികം എക്സ്പ്ലനേഷൻ കൂടി പോയാ
കുഴപ്പമില്ല സാർ, we are running short of time. Yes. Sir, while paying EPF, normally we are capping the salary at 15,000 and pay minimum PF of 1,800 for employees. Will this still possible under the new code of, or should we consider 50% as the basis for calculation? What is the new change?
കോഡ് വന്നാൽ തീർച്ചയായിട്ടും പറ്റുമെന്നാണ് കരുതുന്നത്. കോഡ് വന്നു കഴിഞ്ഞാൽ പിന്നെ വേജസിന്റെ ഡെഫിനിഷൻ മാറിയില്ലേ?
അതെ, അപ്പൊ 50% നമ്മളെ ബേസിക് അതിൽ കൊടുക്കേണ്ടി വരും.
ടോട്ടൽ റിമൂനറേഷന്റെ
we cannot cap at 15,000 as what we normally now the employer does.
അല്ല, അതെ, പുതിയ കോഡ് വരുമ്പോൾ റീസ്ട്രക്ചർ സാലറി റീസ്ട്രക്ചർ ചെയ്യുന്നു. അതനുസരിച്ച് 50% അലവൻസുകളിലേക്ക് മാറുന്നു. അലവൻസ് ഒന്നും അട്രാക്റ്റീവ് ഇല്ല. ബേസിക്, അതായത് ഒരു എക്സാമ്പിൾ എടുക്കുക, 20,000 സാലറി ഉള്ള ഒരാളുടെ ബേസിക് പ്ലസ് DA 10,000 ഇട്ടു, ബാക്കി 10,000 രൂപ ഞാൻ നേരത്തെ പറഞ്ഞ മറ്റേ കൺവെയൻസോ വാഷിങ്ങോ ഒക്കെ ഇട്ട് മാറ്റുന്നു. അതൊന്നും വേജസ് അല്ല എന്നല്ലേ പറയുന്നത്. ആ 10,000ന്റെ മുകളിലാണ് PF അടയ്ക്കേണ്ടി ബാധ്യത ഉണ്ടാവുള്ളൂ, സ്റ്റാറ്റ്യൂട്ടറി ലയബിലിറ്റി. പിന്നെ ഫുൾ എമൗണ്ട് അടയ്ക്കാൻ ഓപ്ഷൻ ഉണ്ട് PFല്, അവർക്ക് കൂടുതൽ എമൗണ്ട് അടയ്ക്കാനുള്ള പ്രൊവിഷൻ ഉണ്ട്. പെൻഷൻ അമൗണ്ടിലേക്ക് അടയ്ക്കുമ്പോഴാണ് ഈ തടസ്സങ്ങൾ വരുന്നത്.
Okay, sir, that is clear. Is professional tax liability coming under Shops and Commercial Establishment Act?
എല്ലാവർക്കും വരും. അത് ഈവൻ നമ്മൾ സെൽഫ് എംപ്ലോയിഡിന് വരും, ആർട്ടിസ്റ്റിന് വരും, ഒരു എന്താ പറയാ പാട്ടുകാരൻ, ഒരു പ്രൊഫഷണലും മതി, എല്ലാവർക്കും വരും. പക്ഷെ അതൊന്നും അടയ്ക്കാറില്ല എന്നൊക്കെയുള്ളതാണ് സ്ഥിതി. സ്ഥാപനങ്ങൾ മാത്രമാണ് പൊതുവെ. വക്കീൽമാരെ അടയ്ക്കണം, ചാർട്ടേഡ് അക്കൗണ്ടന്റ് അടയ്ക്കണം, 20,000 വേണട്ടോ, നിങ്ങൾ അടയ്ക്കണം, നിങ്ങളുടെ വരുമാനം നോക്കി അടയ്ക്കണം.
So when is the liability arise? When we start?
അത് ഒരു ഹാഫ് ഇയറില് ഈ നമ്മൾ 60 ദിവസം ആ പഞ്ചായത്തിന്റെ കീഴിൽ ജോലി ചെയ്ത് കഴിഞ്ഞാല്, അല്ലെങ്കിൽ മുനിസിപ്പാലിറ്റിയുടെ കീഴിൽ ജോലി ചെയ്തിട്ടുണ്ട് എങ്കിൽ വരും. അതാണ് എംപ്ലോയിയുടെ ഇത് വരുന്നത്, 60 ദിവസം ഓരോ ഹാഫ് ഇയറിൽ.
Sir, this question I think they are asking to madam, but the person is doing business from home. Example, online ordering and delivery of food or textile products like that, that kind of items.
Yes.
Whether he is liable for registration under Shop and Commercial Establishment Act.
അല്ല, ഒരു എസ്റ്റാബ്ലിഷ്മെന്റ് ഉണ്ടാവണ്ടേ? അല്ലാതെ ഇപ്പൊ ഇങ്ങനെ ഷോപ്പ് ഉണ്ടാവണം, അയാള് ഫോണിൽ കൂടെ കാര്യങ്ങൾ നടത്തുന്നു.
ഫോണിൽ കൂടി അല്ല സാറേ ഇവിടെ പറയുന്നത്. ഇപ്പൊ അറിയാം, ഈ കോവിഡ് കാലത്തൊക്കെ ഒരുപാട് ആളുകൾ വീടുകളിൽ ഇരുന്ന് ഫുഡ് ഉണ്ടാക്കിയിട്ട് ഓൺലൈൻ വഴി വിൽക്കുന്നുണ്ട്. അങ്ങനെയുള്ള ആളുകൾക്ക് ഷോപ്പ് ആൻഡ് എസ്റ്റാബ്ലിഷ്മെന്റ് എടുക്കണോ? മേ ബി they are selling only through online.
അല്ല, പിന്നെ ഓൺലൈൻ ആയിരിക്കാം, പക്ഷേ ആ വീട് ഒരു എസ്റ്റാബ്ലിഷ്മെന്റ് ആയിട്ട് ട്രീറ്റ് ചെയ്യേണ്ടി വരും. കാരണം അവിടെ നിന്നാണല്ലോ ഓപ്പറേറ്റ് ചെയ്യുന്നത്. ഒരു പബ്ലിക് ഗ്രൗണ്ടിൽ നിന്നിട്ടൊന്നും അല്ലല്ലോ, ഓപ്പൺ സ്പേസിലൊന്നും അല്ലല്ലോ. അവിടെ ഒരു ആക്ടിവിറ്റി ഒക്കെ നടന്നുകൊണ്ടിരിക്കുന്നുണ്ടായിരിക്കില്ലേ? അതെ, അത് ഒരു എസ്റ്റാബ്ലിഷ്മെന്റ് ആയിട്ട്. പിന്നെ GST ഉണ്ടാവാൻ വഴിയില്ല അല്ലെ? രജിസ്ട്രേഷൻ ഉണ്ടാവാൻ വഴിയില്ല.
GSTയുടെ ടേൺ ഓവർ ചിലപ്പോൾ അത്രയും ടേൺ ഓവർ ഉണ്ടാവില്ല. ഇവര് ഇപ്പൊ there are lot of people doing this, especially this COVID ഈ സമയത്ത് കോവിഡിന്റെ
തൊഴിലാളിക്ക് ഉണ്ടെങ്കിൽ എന്തായാലും വരും കേട്ടോ. ഞാനതില്ലാത്ത ഒരു സെൽഫ് ഒരാൾ തന്നെ ചെയ്യുമ്പോഴാണ് നമുക്ക് സംശയമുള്ളൂ. വർക്കറൊക്കെ ഉണ്ടെങ്കിൽ അവിടെ എന്തായാലും വരും. അപ്പൊ ആ ഡൊമസ്റ്റിക് ആണെന്നുള്ള പ്രൊട്ടക്ഷൻ ഒക്കെ പോയി.
തൊഴിലാളികൾ ഇല്ലാത്ത ഒരു ക്വസ്റ്റ്യൻ ആണ് ചോദിച്ചിരിക്കുന്നത്.
അത് ശരിയാ, വെറുതെ ബുദ്ധിമുട്ടിക്കാൻ വേണ്ടിയാണല്ലേ. അങ്ങനെ അതിപ്പോ ഷോപ്പിന്റെ ഡെഫിനിഷനിൽ പ്രമീസസും ഇല്ല, ഒന്നുമില്ല. സ്വന്തം വീട്ടിൽ നിന്ന് തന്നെ ഇരുന്ന് ഭക്ഷണം പാകം ചെയ്ത് കൊടുക്കുന്നു. അത് നമുക്ക് ഷോപ്പ് എന്ന് വിശേഷിപ്പിക്കാൻ പറ്റുമോ? ഞാൻ വീട്ടിലിരുന്ന് കുറച്ച് സ്നാക്സ് ഉണ്ടാക്കി എന്റെ ഗേറ്റിന്റെ പുറത്ത് പോയിരുന്ന് ഒരു ടേബിൾ ഇട്ട് വിൽക്കുകയാണെങ്കിൽ അത് നമുക്ക് എങ്ങനെ വേണമെങ്കിലും പറയാം. എനിക്കത് ഒരു ഉറപ്പിച്ച് പറയാൻ എനിക്കും ബുദ്ധിമുട്ടുണ്ട്. എനിക്ക് എന്റെ മനസാക്ഷി അനുവദിക്കുന്നില്ല അത് ഷോപ്പാണ്, എസ്റ്റാബ്ലിഷ്മെന്റ് ആണ് എന്ന് പറയാൻ വേണ്ടിയിട്ട്. ഒരു കമ്മീഷൻ ബേസിലൊക്കെ ഇരുന്ന് ഫോണിൽ കൂടെ കാര്യങ്ങൾ ചെയ്യുന്ന ആൾക്കാരൊക്കെ ഉണ്ട് അതുപോലെയുള്ള അവിടെ.
Sir, last question. As per the Companies Act, if a new company is incorporated, it will be automatically allowed with ESI and PF numbers.
Recently,
not more than 10 employees and not wishing to comply, any action need to be.
വേണ്ട, അതാ 10 ആവുമ്പോൾ സ്റ്റാർട്ട് ചെയ്യാൻ വേണ്ടി കൺവീനിയൻസിന് വേണ്ടി ഈസ് ഓഫ് ഡൂയിങ് ബിസിനസിന്റെ ഭാഗമാണ് ചെയ്യുന്നതാണ് അതൊക്കെ. ആ സമയത്ത് പണ്ടൊക്കെ ESI നമ്പർ എടുക്കുക, PF എടുക്കുക എന്നൊക്കെ പറഞ്ഞ വലിയൊരു കമ്പൽസറി പ്രൊസീജിയർ അല്ലേ? എത്ര ആൾക്കാരെ മുമ്പിൽ തല കുമ്പിടണം, എന്തൊക്കെ ആരൊക്കെ പ്ലീസ് ചെയ്യിപ്പിക്കണം, പലതും നടന്നിരുന്നു. അപ്പൊ അതൊക്കെ പോയില്ലോ. ഇനി വേറെ ഞാൻ നേരത്തെ പറയാൻ വിട്ടുപോയി, ഒറ്റ വാചകം കൊണ്ട് പറയാം. ഇനി ഇലക്ട്രോണിക് കംപ്ലൈൻസ് മതി, പേപ്പേഴ്സും റെക്കോർഡ്സ് ഒക്കെ ഇലക്ട്രോണിക്കലി മതി. പിന്നെ ഇൻസ്പെക്ഷൻസ് ഒക്കെ തന്നെ ഒരു സോഫ്റ്റ്വെയർ ആണ് സജസ്റ്റ് ചെയ്യുക. ഏത് സ്ഥാപനം പോകണം, ഏത് സ്ഥാപനം പോകണ്ട, ഒരു ക്രൈറ്റീരിയ സോഫ്റ്റ്വെയറിൽ ഉണ്ടായിരിക്കും. അതനുസരിച്ച് ഡിഫോൾട്ടുള്ള സ്ഥാപനം ആക്കി ഉണ്ടാവുള്ളൂ. അതല്ലാതെ അക്കോർഡിംഗ് ടു വിംസ് ആൻഡ് ഫാൻസീസ് ഓഫ് എൻ ഓഫീസർ he cannot enter any premises or conduct an inspection. അപ്പോൾ സോഫ്റ്റ്വെയർ വിൽ ഡിസൈഡ്. അപ്പൊ അതൊക്കെ വലിയ ആശ്വാസരോഗം നൽകുന്ന കാര്യമാണ്. എന്താണ്? ഓക്കെ, വെരി ഗുഡ്. പിന്നെന്താ പറയാനുള്ളത്? അഡ്വക്കേറ്റ് ലിറ്റി ഉണ്ടല്ലോ, നിങ്ങളുടെ കൂടെ ഉണ്ടാവേണ്ട ആളാട്ടാ. ഇന്നൊക്കെ കഴിഞ്ഞ CA ഒക്കെ നിങ്ങൾക്ക് എന്തോ ഭാഗ്യമുണ്ട്, ഒരു വലിയ നല്ലൊരു കോമ്പറ്റീഷൻ